My lord, at the risk of being severely reprimanded, my lord,
One senior is standing. Yes.
My lord, again, I'm sorry to disturb. Yesterday I mentioned this matter. My lord asked me to serve the notice.
Yes.
I served the notice. Then it was handed over to the court officer. He just informed my junior friend, tomorrow, my lord desires you must come and point out to the tomorrow.
Who is your other side?
Other side, I've served the notice. All
Who is your other side?
Nilot Paul.
Bring him. Bring him. Prior to rise him, bring him.
Or my lord can be fixed on tomorrow.
No, you bring him. No issues.
Deeply obliged. Huh? Oh, as I'm sorry.
এটা কেন তুললি? এটা তো 24 দিনের order.
As I'm told, he is not coming today. Maybe for that reasons. I'm helpless, my lord. Kindly fix it.
Court is also helpless.
My lord.
Tomorrow, bring him. Even if it is not there in the list or it's there in the monthly list, bring him.
I'm deeply obliged. Grateful. May I leave, my lord? Grateful.
my lord, at the risk of being severely reprimanded, my lord, I'm mentioning an item number for upgradation, my lord.
But then I am not upgrading.
My lord, only appreciates one thing, my lord. My lord, I'd mentioned also on the monthly list day, my lord. Fraud declaration, my lord, completely without any basis, my lord. An FIR, my lord, has been registered. There's an impending inquiry pending, my lord. I may be arrested, my lord, on any day. That fraud circular, none of the parameters, my lord, on the fraud circular has been followed, my lord.
Just wait for some time. Yes.
That may I be permitted to mention, my lord, one matter for extension of interim order. It is
When is it expiring?
my lord, 30th April. And next week is full of holidays, my lord, for that reason. And my lord, another is, my lord, upgradation for new motion.
No, but an upgradation I will not accept.
My
Yes.
lord,
May I have your
your
lordship's
lordship is
kind
not.
leave? May I have your lordship's kind leave to mention an order dated 3rd April 2025 for correction of some typographical errors in the order, your lordship.
Give.
This is. May I have
Yes.
lordship's kind leave to mention one matter for upgradation, my lord. The
No,
urgency
please
is,
don't
my lord,
mention for upgradation.
yesterday the work order has been issued, my lord.
So what can be done? If it has been issued, nothing can be done.
Lord, kindly consider.
No, sorry.
The contempt matter returnable in 8 May 2025, Lordship. One mistake has been done. Contempt number 2 his title is wrongly recorded Visas instead of Mondal, Lordship. Kindly grant me leave to cause title and then I will be solved.
Mistake is on your part.
Lordship, my lord, this is my mistake, Lordship.
And tomorrow it will appear. Tomorrow contempt matters will be taken up. দেখুন।
Praying for inclusion of application.
No, sorry.
I mentioned your lordship's view was that I shall bring this Mr. Siddiqui so that your lordship can take up. But tomorrow, if this matter can appear, quite higher position in the list, so that I have already talked to Mr.
But
Siddiqui.
the matter is already there in the list.
But it's not going to take up.
Bring your other side. No issues. Yes.
Contempt application. The KMC authority.
No, what you want? Contempt application?
That will be listed.
Let it be listed. Come next month.
Urgent matter by.
Urgent matter. What were you doing on Monday? Every day mentioning for inclusion cannot be taken up. Followed? Yes.
Ladyship, I admonished myself for doing this again. Yesterday, I had mentioned at the time of lunch, your ladyship, the one matter Mr. Shuddhasatya Banerjee had argued before your ladyship. Your ladyship had passed the order. The server copy is yet to be uploaded.
It will be
take it to
uploaded.
task today, your ladyship, because
It will be uploaded. Don't
your
worry.
ladyship, should I hand over a slip with the?
No, don't. Call the list, please.
Your Honor, may I please permitted to mention through virtual mode, my lords? My lord, may I
Last
please
lordship
permit?
directed the Register of Assurance to give your report, lordship. By 5th, lordship, it was directed.
Not given.
Nothing. Till late.
Call Mr. Banerjee. Give a phone call to him. Next.
And for the petitioner, my lord, the last occasion your lordship had directed the other side to take instruction and come back. This is that matter where the railway authorities had filed an undertaking that they will vacate the premises. And not there, madam. Not the regulation. All in that case.
There is one more matter left. If you can bring somebody, then I'll take it up. Otherwise, it will be there in the list tomorrow.
Right.
Item 3.
My lord, I appear for the respondents, my lord.
Appear for the respondents. Any reply served upon you?
Yes, that has been served.
What is the matter about?
My lord, they have challenged, my lord, steps which has been taken as against the promoters for freezing of the demat accounts because they have not complied with the listing obligations and depository regulations of 2015 as set out by the Securities Exchange Board of India.
Please come, none appears on behalf of the petitioner. Learned advocate for the
Your
respondent.
Lordship, I'm here for the petition. I'm being led by the learned senior counsel, Mr. Jayanta Kumar Mitra, and apparently he's unable to be present at this moment due to the resolution being passed. So hence we seek for an adjournment in this matter.
What is being passed?
A resolution was being passed today.
Which resolution?
A resolution regarding the 1030 with respect to the rights that is supposed to be attended today. I'll just show you the resolution, Your Lordship. Just
No,
give me-
please don't show anything. The matter is there in the list and somebody should be there. It's pending from 2024. Accommodation has been sought for by the learned advocate representing the petitioners. Stop. List on 10th of June.
Thank you, Lordship.
Item 1. Yes.
Your Lordship,
very
I
true.
I'm sorry, my lord. I was stuck up. Mentioning, they were so proud. I couldn't come out. I'm very sorry.
Yes.
Tendering my apology.
Where is your report?
I had a talk with him, Lord. Additional list of actions today, my lord. He's preparing it, my lord. He's asking for 2 more days time, my lord, to prepare it. Day after tomorrow, he will hand over. Lordship kindly takes up, my lord. 16, 17 is dicey, my lord. Just after that.
On the prayer of the learned advocate representing the state respondents, time to file the report stands extended till 17th of April.
17th, Lord. Would your Lordship take up just not on the next Monday because I shall file it. I shall get it before that. I'll serve a copy upon my planet.
Till 17th, released on 23rd.
23rd, my lord.
Lordship, if required, Lordship, I shall file by
Exception to the report may be filed
Report
prior
has
to
to be
the
in the
adjourned
form
date.
of an affidavit. It should be in the form of affidavit. No, I'll
Yes, please do
ask
it
him
in
to
the
read
form
affidavit.
of affidavit.
March.
Report in the form of affidavit.
Much obliged, my lord.
Yes.
I'm also extremely sorry. I was stuck in the traffic jam. So far, my instruction is concerned. Kindly, last order passed by your lordship. Direction was given the competent authority to the railway authorities to come with the further decisions in terms of the observation made by your lordship. Already the railway administrations they are in the process of taking final decisions. Yesterday I have received a written instruction from my client that we are seeking only 7 more days before your lordship.
Very well. Learned advocate representing the railway administration seeks a week's time for coming up with further instructions. Stop. In view of such submission, release the matter on 28th of April.
Grateful. Extremely good.
Written instruction shall be produced on the adjourned date.
একজন জুনিয়র কেউ আছে
For the state respondent, Lordship.
Madam, for the petition.
The writ petition has been allowed. and the authority has been directed to grant compensation.
Stipulated time may be granted, other.
8 weeks time has been
Fine.
granted.
I'm grateful, madam.
Yes. এটা একটু চেম্বারে পাঠাবেন তো।
I'm for the petition.
Item number 2,
Similar matter, madam.
similar matter,
Lordship.
but where is the death certificate?
That body could not be found, my lord.
Yes.
Police report is there, lordship.
Where is the police
My lord,
report?
may I assist you? Page 27, lordship. Page 27. To whom it may concern, my lord, this is to certify that on 21/11/15, one Anita Koyal, wife of Anath Bandhu Koyal of Anandapur, PS SDB Coastal, South 24 Parganas, came to PS and reported that on 8/10/15, she left for Panchmukhi River under STR along with her husband, namely Anath Bandhu Koyal and Sipra Mondal, son of Gopal Mondal, all are of same locality, for fishing along with prior permission of forest. During fishing on 11/10/15 at about 13 hours, one tiger suddenly attacked them and beat in the neck of Anath Bandhu Koyal, 50 years, son of
You give notice to your other side, all right?
my lord.
You bring the learned advocate for
Lordship.
the state. What is the way of dealing with these matters required to be seen? You bring,
My lord.
I'll pass orders.
My lord. Great.
Yes, call the next matter. Give a phone call and come back. I'm
Yes.
passing it over.
Yes, yes.
My lord, I appear for the railway authorities. It
How is your spondylosis?
I took painkiller and serious physiotherapy, acute physiotherapy yesterday, and I have been able to come to it.
Where is the
My lord,
petitioner?
This is that matter where in Srirampur station, the unauthorized hawkers were occupying the premises, and Lordship had been pleased to give them a liberty in that whether they can produce any document. They could not produce any document. We gave notice to them, they appeared. And this is totally unauthorized, and we did not take any action, even if the order is passed by the railway authorities on 12th March because of the pendency of the writ petition. This is the order, kindly see.
Please give.
And in the writ petition also, kindly remember, they could not annex any document.
Yes, yes. Please come. None appears on behalf of the petitioners at the time of call. Stop. The learned ASGI submits the speaking order dated 12th March 2025, passed by the Divisional Railway Manager, Eastern Railway, Howrah, clearly mentioning that a personal hearing was given to the petitioners and they failed to show any supporting documents in their favor, permitting them to run business from the railway station or the precincts of the railway station. Stop. The authority directed the petitioners to vacate the railway premises within 48 hours after 21st March 2025.
That was your lordship's interim order.
The said period is long over. Stop. Paragraph. It will be open for the railways to proceed with the eviction drive. Writ petition stands disposed of.
And the speaking order will be taken on record.
The speaking order is written with the records.
Yes, sir.
Date ta likhe neben 12/3/25.
My application. my lord.
Yes.
Service.
Union of India,
What is the affidavit of service? No.
was it served?
Served. Yes, my lord. I haven't personally checked. Yes, my lord, it was served. Look, the only difficulty is served. No. Yes, my lord, I'm told it's served.
Railways. Yes. What is it? What is the matter about?
problem is the offending document is page 37. My lord, there's a demurrage and Lord, what happens is I take the goods, put it and take it somewhere. Now, because of some other parties interplay here, I could not take the goods from the railways and transfer it somewhere. They've imposed demurrage and forfeit charges. Now, my application seeking waiver is pending. If your lordship looks at page 37, Lord, my only difficulty is this insofar as district petition is concerned. This is of 26th of March. There is a pending outstanding for an amount of 9,87,000 on account of demurrage charges against Messrs. As the petitioner. It is requested to realize so and so from Neometallics Limited. This is the senior divisional commercial manager writing to the it's an inter-department communication. Under intimation to this office, while generation of upcoming RR, as there is no outward rake for loading of Messrs. Neo from this division. So what they're doing is, because this realization is so-called pending, so there are two representations that are pending. One is that I am not liable to pay this amount at all, because under the guidelines, this is not payable by me because this was at the instance of another party. What happens is it's taken down, the goods are brought somewhere else.
Where is your application? Seeking waiver of payment of the demurrage
Waiver
charges?
is at page 28. 3rd of December 2024. But what they've done is they've not considered this. They've not considered the other representation. Waiver is where I say that you waive, although I'm liable to pay. There is another representation which says I'm not liable to pay at all. Where is that?
But don't you think both are contrary to each other? Once you say you are liable and then waive, and the other you say that I'm not liable.
Both. Because one is that the waiver will be applicable under clause 2.9 or 2.11. I'll just show that. Here I have raised the issue of the liability itself foisted on me is illegally. Because somebody else comes and parks their train, whatever, the loading thing in front of me. That's another partnership firm, third party. With them, I have absolutely no privity. There's a partnership firm called Innocent Traders. They have also been levied demurrage, but not wharfage. Now, it's an admitted position that I could not take the goods down because they had parked it in my place. Now, in spite of that, there's a demurrage and forfeit charges that's been levied on me. Well, that representation they don't consider. My waiver they don't consider. Now, my entire business has come to a standstill because of page 37. They are not issuing any orders under the contract in my favor to unload these goods any further because this is pending. But realization, if it at all is there, first they'll have to consider these two. They can't halt my contract itself and not give me any unloading orders because this too is pending. There is no case made out of any lien. In fact, they can't even exercise lien
Page
here.
27, your representation mentions up 27.
Yes.
It mentions about refund of the demurrage charges. Is anything there with them?
This was the 10 lakhs that I had paid by mistake. Then we prefer an application before your lordship. Kindly have a look at that order. That order your lordship will find. My lord, I'll just indicate, my lord. We had to withdraw the writ petition. Kindly have a look at page 34.
Yes. That is incurable defects, but then you...
That's right. So and this payment was made before that. We made that payment by mistake. Then we have two representations before them saying at least consider why at all this is not leviable on me. Well, while this consideration is pending, they've withheld all the orders that are to be given to me. Well, this possibly can't be countenanced in law. A statutory authority
They can't use these arm twisting measure to recover the money. And your lordship will not find the case of lien being made out anywhere. Because lien, if it is at all there, it has to be levied. Your lordship is aware that lien can be marked only when there is a debt that is crystallized. Lien can't allow them to withhold supply or withhold services under the agreement. Here at page 37, there is no outward rake for loading. So they're not even allowing me to place it. The contract is in subsistence. Lord, my only prayer before your lordship is let them consider all this. But while this is being considered, they will not withhold any outward rake for loading on my.
Send me this letter on page 35.
Lord, if your lordship looks at page 35 once, this is how they deal with my application for waiver. This is the 17th of March. This is to inform you that an amount of so and so is lying outstanding since long against your firm on account of demurrage charge. In this regard, several letter reminders already been sent to you, but despite of that, payment has not yet done. However, you're once again requested to. So, a statutory, the railways are levying two different components of charges on me. One is demurrage, the other is wharfage. I am saying that this is not payable. Let them consider this. In the meantime, they'll not withhold this. Not my contract. My only business is to supply to these services with the railway. Essentially, it impinges on my fundamental rights.
The petitioner is aggrieved by the communication made by the Senior Divisional Commercial Manager, Eastern Railway Asansol, dated 26th March 2025, addressed to the Senior Divisional Commercial Manager, Southeastern Railway, Chakradharpur. Directing the addressee to realize the sum of rupees 9,87,660 plus GST from the petitioner on account of demurrage charges. What is this RR? While generation of
upcoming railway receipts,
as there is no outward rake
for loading.
Yes. According to the petitioner, according to the learned counsel for the petitioner, the petitioner is not entitled to pay, not liable to pay the demurrage charges. Not liable to pay the demurrage charges. What about wharfage?
And wharfage.
And wharfage. Stop paragraph. The sum of rupees 10,37,043, which was mistakenly paid by the petitioner, has been sought to be refunded. Stop. During the pendency of the representations filed by the petitioner requesting refund of the charges and mentioning that the petitioners will not be liable for payment of the demurrage and wharfage, the Senior Divisional Commercial Manager, Eastern Railway Asansol, has passed the order for realization of the said amount. Stop. The petitioner is aggrieved by the same. Stop. None represents the respondents despite service. Stop. Affidavit of service filed in court is taken on record. Stop. Paragraph. As it has been submitted that because of the impugned communication, the petitioner's business has come to a standstill, the instant writ petition is disposed of by directing the Senior Divisional Commercial Manager, Eastern Railway, Asansol, to consider the representations filed by the petitioner. Now, respondent number 2, the General Manager within bracket operation, Eastern Railway, to consider the representations filed by the petitioner after giving a reasonable opportunity of hearing to the petitioner to defend its stand in accordance with law at the earliest, but positively within a period of 7 days from the date of communication of this order. Stop. A reasoned order shall be passed and communicated to the petitioner immediately thereafter. Writ petition disposed.
In the meantime, they'll not withhold.
7 days. This is the reason the time period has been reduced. Yes.
I appear on behalf of state, my lord. Last occasion, my lord, your lordship directed the school authority, that means Mr. Kamalesh Bhattacharya is appearing, to take instruction from the school authority. Kindly seek the order, my lord. Last order.
Yes. Now today Mr. Bhattacharya is not there.
My lord, despite of order passed by Honorable Justice Kapoor, no steps has been, positive steps has been taken against the petition.
Yes.
Mr. Kamalesh Bhattacharya appear for the, my lord,
No, you are also appearing.
my lord, my lord, the authority, school authority, today morning, my lord, instruction me, and I'm praying for 2 weeks time for affidavit, my lord.
Why?
But directors came in to file affidavit. No affidavit has been filed. Delete the matter.
The matter is there pending from
Yes,
2023.
ma'am, only 2 days, my lord. Time.
2
days, my lord.
2 days.
2 days.
Yeah, I will give you 4 days time, but pay costs.
Well, just today morning, my lord.
No, today morning the order was passed on 26th of
Yes,
March.
my lord.
Why today morning you are telling me? Nothing doing.
Report, my Mr. Kamalesh Bhattacharya is also not.
Do not take his name. You are there and you are conducting the matter. The person is going to retire on 31st of January 2026. Till he uploads all documents, he will not get his terminal dues. Then, and you take things so lightly. Please come. Learned advocate representing this school seeks time to file an affidavit. Stop. Paragraph. It appears that the school is dilly-dallying with the matter for a considerable period of time. Stop. The petitioner is due to retire in the month of January 2026. Until his period of absence is not regularized in accordance with law, he will not receive his terminal dues. Stop. Paragraph. The stand of the school is highly deprecated. Stop. For ends of justice and as last chance, the the hearing of the writ petition stands adjourned till 6th May 2025. Stop. Affidavit by the school shall positively be served upon the learned advocate for the petitioner by 21st of April. Stop. It will be open for the petitioner to file exception to the affidavit filed by the school prior to the adjourned date.
6th May.
আমার কাছে খবর না এলে জানবো না, কি করে জানবো? আগের বার আসেনি।
My lord, I'm sorry, my lord. My lord, item number 4, it was 1538 in the monthly combined list, but he has mentioned and brought the matter in the list supplementary. I suddenly have seen the list matter, my lord. I rushed to the court, my lord. item number 4 just before this
It
matter.
has been disposed of.
Disposed of, my lord.
Yes.
Representation.
Representation has been directed to be considered. Bring your other side. Bring your other side.
Yes, ma'am.
And then your appearance, and if you have any instruction that can be recorded. Otherwise, it has gone down as none appears.
Oh, yes, madam. I'm just bringing.
Please bring.
Yes. Huh? Con-
Item 6. None appears on behalf of either of the parties. List on 28th of April.
My lord, I'm for the petitioner, my lord.
Ashwin, I'm appearing on behalf of SEBI.
SEBI. Yes.
In this matter, the petitioner is the investor in the stock market. He is doing his act of investment through registered stockbroker. Now, on my lord, July 30, 2021, one so-called notice was issued against the writ petitioner. Now, the case of the writ petitioner is that the so-called notice was not received by him because this was issued in the pandemic period. Now, the authority passed the adjudication order on February 17, 2022. Now, the adjudication order is at page 48, my lord. This is under challenge, my lord. Page 48.
Yes.
Now, my lord, paragraph number 1. Securities and Exchange Board of India conducted investigation into the trading activity in illiquid stock options on BSE Limited for the period April 1, 2014 to September 30, 2015. Now, the period is very important. April 1, 2014 to September 30, 2015. Now, my lord, kindly consider para 2. Pursuant to the investigation, it was observed that during the investigation period, total of 291,744 trades comprising substantial 81.41% of all the trades executed in stock option segment of BSE were non-genuine trades. The aforesaid non-genuine trades resulted into creation of artificial volume to the tune of 826.21 crore units or 54.68% of the total market volume in the stock option segment of BSE.
Yes, yes. Then what has happened? It's a big order.
Now, my lord, the ordering portion is at page 62.
Yes.
Kindly consider the first paragraph, 31, my lord, paragraph 31. After taking into consideration all the facts and circumstances of the case, the material available on record, the factors mentioned in section 15J of the SEBI Act 1992 and in exercise of the powers conferred upon me under section 15(1)(2) of the SEBI Act 1992 read with Rule 5 of the Adjudication Rules 1995, I hereby impose a penalty of rupees 5 lakhs upon the noticee. That is Ankit.
Yes,
Now, my lord, they have referred the regulation PFUTP regulation 2003. Now, my case is that under this regulation, the investor does not come. Kindly consider, my lord, the first page, the definition clause, my lord.
Investor does not come.
My lord, kindly consider definition clause 2(1)(b), dealing 2(1)(b), my lord. Dealing in securities includes an act of buying, selling, or subscribing pursuant to any issue of any security or agreeing to buy sell or subscribe to any issue of any security or otherwise transacting in any way in security by any persons, including as principal agent, intermediary, referred to in section 12 of the Act. Now, this inclusive definition has been incorporated in 2019. Before that, what was there, my lord? Kindly consider, my lord, at the bottom, dealing in securities. Dealing in securities includes, this was by any person as principal agent, intermediary, referred to in section 12 of that. Now, the petitioner is not principal agent or intermediary. This inclusive definition has been incorporated in 2019. Event was 2013-14. First. Now, my lord, second thing, my lord, kindly
tell me one thing, whether the order of the adjudicating officer is appealable or not.
Yes, your lordship, your lordship has asked the correct question.
Thereafter, my bank account
Tell
has been
me
seized.
whether
I
it is-
have preferred appeal with section 5 application. That appeal has been, the section 5 application has been rejected. Thereafter, I preferred the review application with the section 5. That section 5 also has been rejected.
Rejected. So now there is, apart from the writ court, there is no other
No.
place
Your
to
lordship.
go. This is your submission.
No.
All right.
Your lordship,
Yes.
if I may, before we get into the merits of the case, I would just like to indicate section 15Z of the SEBI Act.
No, let it
Yes, your
remain.
lordship. I'll just read it out if your lordship permits.
No, there is no requirement. You file your affidavit. We'll see what
Your
is to
lordship,
be
the
done.
Supreme Court remedy is available.
Supreme Court
Yes, your
remedy.
lordship.
They cannot approach to the writ
No,
court.
your lordship, they can go to Supreme Court. Your lordship, 15Z says, any person aggrieved by any decision of the SAT may file an appeal to the Supreme Court within 60 days from the date of communication of the decision or order of the SAT to him on any question of law arising out of such order, provided that the Supreme Court may, if it is satisfied that the applicant was prevented by sufficient cause from filing the appeal within the said
That is the
period
delay
allowed.
portion. That
Yes,
is-
your lordship.
No, but then how can Article 226 jurisdiction be taken away? It cannot be.
Your lordship, but when there's a remedy available to them,
No,
then why
they-
are they invoking the writ jurisdiction, your lordship?
File your affidavit, please come.
But your lordship, my objection needs to be recorded that
Yeah, you
there's
file
an
everything
alternative
by way of affidavit. The instant writ petition is required to be heard. Stop. Let affidavit in opposition be filed by the respondents within a period of 8 weeks. Reply, if any, within a fortnight thereafter. Stop. Liberty to mention the matter for hearing. Stop. The objection raised by the learned advocate representing SEBI regarding maintainability of the writ petition is kept open to be decided at the time of final hearing.
Oblige.
Take back the act. Yes, service is taken. Service.
Oblige.
My lord, item 2, my lord, my learned friend has come. Item 2, my lord.
Yes.
Mr. Yusuf.
I'm not here in the first.
Yes. In the first matter, the court has passed order for grant of compensation because the postmortem report was there. Here, the body was taken away by the animal. This is what has been said. What is your way of dealing these matters? If the body is not available, what do you all do?
Lordship, on this specific point, your lordship, I have to take instruction, but from the report it appears that he was crossed the prohibited area, lordship. What it appears from the report, lordship.
Do we take it that the body was actually taken away by the animal? It may be.
It may be, lordship. When it
Right.
is not found.
It is not found.
Lordship.
And there is a police report, not report, it is exactly the version of the video that has been mentioned by the police.
When the body
So
is not
I
available.
will require one paragraph from your officer mentioning what happens if the body is not available and is allegedly carried away by the animal. So that necessary order can be passed in similar cases, you all can use it also. Because somebody goes somewhere else and says that the tiger has taken away the body, you never know.
Lordship, I will take the specific instruction
But,
on this.
may I submit one thing? That point was dealt with by the coordinated bench, my lord, page 47, as your lordship got it, my lord. My lord, page 47, paragraph 3.
7.
My lord.
Yes.
Paragraph 3. Insofar as the husband of the petitioner in WPA such and such is concerned, he was also a victim of the same tiger attack. When the person tried to save the victim in WPA such and such, he was mauled and seriously injured by the tiger and ultimately succumbed to his injuries. The difference with the other victim is that his body could not be recovered.
His body could be recovered.
Could be recovered. Thereafter, my lord, a postmortem happened to the
Yes.
body of the victim in case of the reason since the body could not be traced out. Thereafter, my lord.
Where? Which portion?
In case of such and paragraph
Well,
4.
postmortem happened to the body of whereas the same could not take place. In both the cases, death certificates have been duly produced. How can death certificate be produced if the body was not available? Let him take instruction and come back. I'll pass order. Please come. How soon?
77 minimum.
আচ্ছা ঠিক আছে the body of the petitioner's husband could not be found, could not be traced out, allegedly because the same was carried away by the tiger. Stop paragraph. The court has passed order directing grant of ex gratia compensation to the heir of the victim. Stop. As in the instant case, the body could not be traced, comma, the principal conservator of forests is directed to file a report with regard to the procedure adopted in cases, procedure adopted for grant of compensation in cases where the body remains untraced. Released on 28th of April.
No. Yes, my lord. Yes, come.
Item number 4. It has been mentioned that it was upgraded without notice. Did you get notice?
No, my lord, I have not.
He is entering appearance today.
Yes,
I have
Yes.
been engaged by the department, my lord, by the railway, my lord.
Right.
Then, my lord,
And your department, did your department receive notice?
I do not know, my lord. I have seen
If your client does not give this notice, where is the notice of upgradation? Please show.
I'm told it was handed over while mentioning.
While mentioning. Fileটা দেখুন তো একটু।
But item number 1538 in the list, my lord, combined monthly. That was I
Maybe.
was under impression, my lord, that.
So my difficulty, my applicant record is also left. So I was here, he could get me from the file actually.
নোটিশটা আছে? See, the notice of upgradation is there and it has been received by your client.
By the
There is a seal.
by the department, my lord.
Yes.
My lord, then I have not been. I'm sorry, my lord, I have not been told, my lord. I have seen the matter today in the list, my lord. That's not
Then
outcome.
at best what can be done is your name can be recorded, but no, I will not
My lord,
change
your
anything.
lordship has said, my lord, only, my lord, that representation should be, my lord,
The
considered
representation to be considered within a week.
within a week, my lord. Week is, my lord, a little bit.
He is suffering.
Well, 2 weeks at least, my lord. 1 week, my lord, it's not possible. My lord. Holidays are there, my lord.
Oh, you do not have holidays.
My lord, they have also, my lord, lots of 2 weeks, my lord. At least not so to consider the represent at least 2 weeks.
I think 2 weeks.
2 weeks, my lord.
Very good.
And my lord, none appears your lordship. has said.
Yes, I'll delete that. And I'll write Steve Prasad Sharma over there in bold
Chandra
letters.
Prasad, my lord, your lordship has not
Chandra
forgotten my
Prasad.
name, my lord.
Yes.
And then that I appear twice, you know, that we also have the benefit.
Yes, double fees.
I'm grateful, your lordship.
Next.
That's not 2 weeks.
My lord, I'm appearing for the petitioner. I'm appearing for the petitioner, my lord.
Yes.
I'm led by Mr. Anik Pandit. He is currently engaged in the Alipur district judge court, my lord. I'm praying for a passover.
This is not the ground for seeking adjournment, and the court will not permit. Where is the advocate on record?
And I'm the advocate on record.
Where is your file?
My lord, it is currently with the senior only.
The advocate on record should always keep a copy of the writ petition.
I know.
It is not meant to carry a copy.
Sorry, my lord.
And you should learn this from the very beginning. Are you aware of the facts of the case?
Not as much as my.
You have signed this writ petition?
Yes, my lord.
Did you go through the writ petition?
My lord, I'm not as much as aware as my senior is.
Tell me whether you have gone through the brief or not prior to signing.
Yes, my lord, I have.
Were you present during the time of conference?
Yes, my lord.
So you must be knowing the facts. What is it?
My lord, there is a FIR pending since 2012 against the petitioner. At the age of 14, he was at class 8. He attempted suicide along with one of his friends. They both jumped it from a 4-story building. The girl died on spot, but he somehow survived. And later on, the parents of the girl lodged an FIR against him. And his mother was also charged. There was an FIR against his mother also, but she got discharged. And the senior was, the principal of the school was also there, but he too got discharged. Presently, my lord,
there was a direction for service of notice upon the state respondents. Did you serve?
My lord, the service has been done, but affidavit is still yet to get affirmed. I will submit it within today.
Within
today, I will submit it.
How can you serve it within today? Nobody is there for the other side.
My lord, notice was served.
Take down. An accommodation has been sought for. On behalf of the petitioner. Stop. None appears on behalf of the respondents. List on 28th of April. Let further notice. Now let the learned advocate representing the state respondents be put on notice. Call the next matter.
My lord, I am appearing for the petitioner, my lord.
Yes.
On earlier occasion, your lordship direction was to the Howrah Municipal advocate of the Howrah Municipality, my lord, to serve the status report, my lord, regarding my
fresh water connection.
Fresh water connection.
What has happened?
My lord, I am placing. I have taken instructions, but status report in the form.
Very well. What is it?
Day after tomorrow. I am placing. Page 120, page 23, madam.
Yes.
There is an order of this honorable court that on a third paragraph, on a perusal of the application made by the period, it appears that none of the applications was either forwarded or addressed to the commissioner. According to law, the commissioner is the appropriate authority. Under 136, madam, there is the appropriate authority to take a decision in the matter. In view of the
my lord, I'm for the state, my lord. Led by Mr. Jayanto Samanto.
Appropriate application before the commissioner seeking water connection in the event application is made, connection should be given in accordance with law. Now, my lord, they have made an application there on the next page. My lord, just on the page thereafter, annexure P5, as per order of Honorable so-and-so.
He has been requested to submit the application through the registered. He has not done?
Next page. He says that already order has been passed by this honorable court, so please give me water connection. So that form of application is not done. Page 130, section 136 says
you have to file the application through a registered plumber. Why are you not doing it? Without a proper application, how can the corporation proceed with your claim?
I have made an application, my lord, on 31st January of 2024, my lord.
Please come to page 26 of the writ petition.
26.
Yes. You have been requested to submit your application through the registered plumber because this is how the law stands. Have you made that?
That has not been done.
You are unnecessarily coming to court to get orders without actually making an application. What is it?
Petitioner is quite ignorant regarding the.
You know the law?
Should be.
You should advise your client as what is to be done. Why was the writ petition filed? You ought to have advised your client to file an application through the registered plumber. You filed the writ petition. I'm going to dismiss this with costs for wasting the court's time. Please come.
The representation which was required to be considered by 31st January, here it is written, I have already got an order from the Honorable Court, so this representation will also not.
The water connection application. No. The prayer for water connection made by the petitioner cannot be proceeded further. Cannot be proceeded as the petitioner is yet to submit his application through any registered plumber of the Howrah Municipal Corporation with relevant papers in his support. Stop paragraph. It appears that way back by a communication dated 11th January 2024, the petitioner was apprised of the requirement of submitting application through registered plumber of the Howrah Municipal Corporation with all relevant papers in his support, like the deed, the plan, mutation, etc. Stop. The same has not been done. Stop. The petitioner has approached this court all over again with a prayer to direct the corporation to proceed with his water connection application. Stop paragraph. The petitioner ought to appreciate that till a formal application is filed through the registered plumber with relevant documents, the corporation will not be able to proceed with the same.
And other documents required.
In view of the above, the instant writ petition is disposed of, granting leave to the petitioner. No, not granting leave. Disposed of with the observation that it will be open for the petitioner to make application through registered plumber of the Howrah Municipal Corporation with all relevant papers in support of his claim for getting water connection at the subject premises.
Dealing which we cannot.
Paragraph. In the event such an application is made in the prescribed form with the relevant documents, the corporation shall consider the same in accordance with law at the earliest, but positively within a period of 8 weeks from the date of
making such application.
Disposed.
Grateful, man. Grateful.
My lord, I am for the petitioner led by Mr. Rishabh Chandra.
Ladyship, I beg to appear for the writ petitioner. Ladyship, I am being led by Senior Counsel Mr. Jishnu Saha. Ladyship will recollect this matter was partly argued by Mr. Saha on the 2nd of April. Unfortunately, Ladyship, today Mr. Saha is in some difficulty and he has requested if the matter may be kept tomorrow with the same caption subject to Ladyship's discretion. We will be highly grateful. Ladyship had asked us to find some additional judgments, and this is the same matter where the DRAT had dismissed the appeal for not granting waiver before hearing the condonation. My only request is if it can be listed tomorrow.
An accommodation has been sought for by the learned advocate representing the petitioner. Stop paragraph. Release the matter on 21st of April.
Ladyship, the adjourned motion high on board caption may kindly be retained, Ladyship.
Yes, it will be there.
Highly grateful.
For the petitioner, I am praying for an accommodation, my lord. There was a direction upon the learned advocate general to appear, my lord. Learned advocate general is still not available in the court today, my lord.
Not available in the court?
Well, we have handed over the brief, my lord, but we can't hold any conference with learned advocate general because of the busy schedule, my lord. But today I got information that he is not available in the court till now.
My lord, this is that hospital patient.
I can see. The person is also present. That also I can see. even if the AG is not present,
My lord.
at least get certain observations, opinions, views, anything from the state.
My lord, the views are very clear, my lord. My lord, we have structure, but we don't have medical facility.
No, no. What is the remedy? This is what the court wants to know.
Lordship,
In
Lordship,
yes, I know.
I
Your
understand.
stand.
I
The
understand. I
firstly
understand.
you have disclosed. But the court cannot permit the lady to be thrown out of the hospital.
Lordship,
That cannot be done.
But my lord, at the same time, when the husband is present, when the husband is available, he is recognizing that she is his wife. There might be some medical problems. There might be some wrong in the part of the hospitals, whatever it may be. But he should take the responsibility. This is the whole problem, my lord. Every patient who is going to the hospital, they are not coming out fully fit, my lord.
Yes.
I've got the entire history of my lord, what had happened. My lord, this lady was driving on a.
Whatever. See, they know you.
So what her status is, I've got. I'm totally ready
Well,
about that.
whatever the history is.
So the legal position, my lord.
Yes.
My lord, if there is no one to look after, my lord, under Article 21, right to shelter, right to health. Now, my lord, there are several judgments. I've got all of them. It is the state's responsibility.
That is the reason I requested the presence of the AG.
Lordship, kindly give another date.
Follow it.
I've come ready with all the judgments in law also. And here, my lord, the
An accommodation
fault
has
was the
been sought
husband's
for.
completely.
By the learned advocate representing the state on account of unavailability of the learned advocate general.
My lord, the treating doctor, he's also present here today, my lord. In case your lordship wants to speak to him.
Stuff next. On such prayer, release the matter on 16th or 17th?
May I request for 21st?
21st.
21st, my lord.
Grateful, Lordship. I am assisting Mr. Mukherjee.
Record the presence of the husband in court. The husband is personally present.
Well, this is my petition. Lordship may recall, this is the Axis Bank again. Lordship, Axis Bank, twofold. Firstly, it froze my account without an order of court. And secondly, they are even their objection was there is a case pending against you, it's been dismissed. So after that, there can be no justification whatsoever. And I'm covered by two judgments. One is a recent judgment, even though it's a private bank, mandamus has been issued by our Honorable Chief Justice against Axis Bank for freezing an account. Now, Lordship kindly takes a look at for Lordship kindly takes a look at an ombudsman. We have tried our luck in the alternative remedy. It's been futile, as I have shown that they have just been shunting us off on the ground that an appeal from that order has been filed, and that is still pending. Now, she kindly takes a look at the freezing of the account by Axis Bank and the reason given for such freezing. Now, she apropos to Axis Bank.
I'm for Axis Bank.
You're for?
I'm for Reserve Bank of India.
He's a Reserve Bank of India. For the yes, we had been.
Number 4.
Lordship kindly takes a look. Axis Bank could have bull the freeze police.
Page 20.
Lordship, page 175, Lordship. Page 1, volume 1, page 175.
Yes.
Kindly see I had shown it last, but I'm just reminding my second paragraph. Kindly also note that we have received a separate letter on the letterhead of August, having registered address Birla Building, alleging inter alia that there has been illegal and wrongful appointment of certain persons as directors of office, and intimating us not to act upon the EOGM or on the basis of any resolutions passed by persons claiming to have been appointed as directors at such EOGM. The August letter 2 was enclosed. One copy of board resolution for not giving effect to any change pursuant to the EOGM. on any resolutions passed by persons illegally appointed at such EOGM and copy of letter dated 2nd April issued by Ministry of Corporate Affairs addressed to August as company to Vindhya Telelinks, informing that MCA has taken note of the inter-management dispute and requesting to settle the matter amicably or get an order, interim order from a court or tribunal of competent jurisdiction till such dispute is settled. And the documents filed by August and the contesting groups of directors will not be approved, registered, recorded, and thus not be available in the MCA. We also note that the registrar of companies site as on 8 June continues to reflect the registered office, address and names and directors of August as per the attached extract. Under these circumstances, we are unclear whether the EOGM and Board Resolution 1, whether BR2 has been held in compliance with all the provisions of applicable law, including section 100 so and so. Including the list of so and so, to verify the matter. Kindly also note that in order to safeguard the assets of August with Axis Bank, the bank accounts and demat accounts maintained with us, we have marked a freeze on the same. Or just a few backgrounds, what I pointed out. I have only one shareholder, that is Vindhya Telelinks, who's 100% shareholder. I am a 100% subsidiary of Vindhya Telelinks, who is the pro forma respondent here. They appear largely to Mr. Bachchan.
Now, we are appearing for
so now, Balot, there was a inter-management dispute on the website of the Ministry of Corporate Affairs, which has been withdrawn, expressly removed that that removal of the inter-management dispute, page 200. Page 200 expressly removed. That is volume 1 itself, last page. Please note that the company August Agents has been demarked as having management dispute with the following. So it is demarked. So one problem resolved here.
So does page 200 suggest that the management dispute is no longer there?
In the records of the registrar of companies, there is none.
None.
But this is followed by a company petition filed by the removed directors, because they file a company petition before the National Company Law Tribunal, which is ultimately dismissed by the order, which is at page 239, second volume, 234. Which is finally dismissed. Lordship, kindly come to operative part at page 275. At 270, yes, 275 issue. Kindly see paragraph 10. Lordship, kindly come to the operative part, issue A at page 277. 277. And Lordship, may I come straight away to the final direction given, that is at page 282. Last 3 lines of page 282. The company recognizes only the registered holder of shares. That is the person in whose name the shares stand on the register of members of the company. And such person is the only person lawfully entitled to enjoy the statutory rights associated with the share. This is the finding. In view of the discussion, the petition is not maintainable and dismissed. Now, this is also gone out of the way. And Axis Bank had filed interim applications, which are also dismissed. Intervention applications, paragraph 15, those are also dismissed. Then, my lord, After that, there's an appeal.
No stay. Axis has not challenged something.
Axis has not challenged the order. The disgruntled erstwhile directors have challenged. There's no stay, no interim. Now, this is the position. I'm coming to twofold. Firstly, the freezing of the account is bad because it's been judicially held by our division bench also that freezing of a bank account can be only on three grounds. The bank can freeze only if there's an order of court. Number two, if there's an RBI directive. And number three, if there's a lien of the bank. Not on the basis of a complaint. Lordship, that has been division bench kindly takes a look at the Lordship kindly takes a Modelo. Kindly takes a look at this is followed by the division bench also. You kindly takes a look at paragraph 5. The law with regard to a unilateral debit freeze of a bank account is well settled. A division bench of this court considered the issue in FMA 74/2020 and specified the circumstances in which an account may be debit freezed by a bank. The circumstances include an instruction from the Reserve Bank of India or a lien which the bank proposes to exercise on the funds lying to the credit of the said constituent. Here there is no loan. The division bench was of the view that a freezing order can only be obtained from an appropriate forum and not in the instance of a constituent of the bank. And the order was made accordingly. This has been followed by the division bench of our High Court. It kindly takes a look at the division bench of the High Court in Cardiological Society of India. In Cardiological Society of India. But should kindly comes to paragraph 20. Paragraph 19 and 20. 19 is the first respondent approached the writ court challenging the action of the respondent bank of debit freezing the bank account of the West Bengal branch with the MCC branch of the state bank. A coordinate bench in the case of Rina Habiba held that in the absence of a bank either having claim against the constituent or a lien of the bank account, or the bank being obliged to obey any instructions of the central bank or any order of court, a bank cannot freeze any account of its constituent for any period. The coordinate bench held. And Lordship kindly, paragraph 21, this Modelo is followed. And paragraph 23, has to be defreed. But then, with regard to operation of account, there was certain directions given. That is not who will operate the account. Paragraph 23 is what follows that. We could have come then and there, but be that as it may, we had gone to the Ombudsman. It turned out to be a futile exercise. And now, my lord, kindly come to an issue which may be raised, that Axis Bank is a private bank. So this writ may not lie. What that possible argument could be. The Ombudsman in that case also was not doing anything. Now she kindly takes a look at. There it was a no due certificate case. Paragraph 2. By the impugned judgment and order, the writ petition was allowed and the appellant bank was directed to issue requisite no due certificate to the writ petition number 1 herein and return all the security. Now, Lordship kindly comes to paragraph 24 on. Paragraph 23. Clause 15 deals with award of ombudsman. After reading the said clause as a whole, this court finds that the ombudsman is under an obligation to consider the record placed and afford a reasonable opportunity of hearing to both the parties. The ombudsman shall have to take into account the principles of banking law and practice, directions, instructions, and guidelines issued by RBI from time to time, and such other factors as may be relevant before passing a reasoned order. The ombudsman in his award can also direct specific performance of the obligations of the regulator. 35A of the Banking Regulation Act vests power upon RBI to give direction. 45L, so Lordship kindly come to paragraph 27. 28, Judicial Authority has to give reasons in the order. None of this is here. So the order in this case is quashed, and Lordship then sees what the court has done. Paragraph 33. For the reason that I will show the order here, so it quashed and it was not sent back to the ombudsman. It was then that the court issued the mandate. Kindly come to paragraph 37.
Yes.
Paragraph 37 there. After going through the material on record, and particularly stand taken by the party, this court finds that there is no disputed question of fact involved, requiring detailed evidence, but interpretation of the provisions of the Contract Act and the relevant terms of the agreement are involved. That apart, the learned single judge, after interpreting the relevant provisions and the terms, has allowed the writ petition. Therefore, this court has to test the correctness of it. Now, Lordship kindly comes to the various issues regarding money to be sister concerns, dues, etc. But kindly come to the order at page 58. Paragraph 15. Paragraph 15. Last page. For the reasons as stated aforesaid, this court holds that failure on the part of the bank to return the title in respect of the property at Sector 5, Bidhan Nagar, Shore Lake, and to issue no due certificate, even after repayment of the credit facilities, amount to deficiency in service on the part of the appellant bank, which is a regulated entity under 2021. The order of the learned single judge directing the appellant bank to issue the requisite no due certificate to respondent number 1 and to return the title deed with the property as well as other securities, but does not call for its appeal. For the reasons as aforesaid, the appeal is allowed in part the impugned order directing return of the original pledge agreement as well as share of the stand set aside, because there it was a sister concerns dues itself. There were a guarantor. So that was kept aside and rest was mandamus was part. Here, Malad, there is no dispute that there is no order of court directing freezing of bank account, the grounds on which they can freeze an account. There is no lien they have exercised. There is no RBI directive to freeze the account.
Yes.
Today I will be submitting only on May 21. This is the judgment I will rely on.
Copy the. I challenge the ombudsman's order.
Lordship kindly comes.
Ultimately,
Your Lordship, all the private concerns, those are working under one or other ministry. So license, all the private concerns are not only banks. Every private concern is getting the ministry from the guidance from the from one or other ministry. So that does not mean that private concerns will be governed by Article 12. Those are amenable to Article 12. My Lord, kindly comes to point number 9.
Well, I've got a very able junior Lordship kindly gives me leave for Mr. Gupta is more than competent.
The judgment is
Paragraph 9. Which page is it? Page 9, I got it. We may sum up.
We may sum up. For issuing writ against legal entity, it would have to be an instrumentality or agency of a state or should have been entrusted with such functions as are governmental or closely associated therewith by being of public importance or being fundamental to the life of the people and hence government. Lordship. Now, point number 2 has been summarized, the 226, Article 226. I'm not going into it. Now, your Lordship, 3 and 4 is most relevant. Although a non-banking finance company like Muthoot Finance, since the matter was of Muthoot Finance Limited, with which we are concerned, is duty bound to follow and abide by the guidelines provided by the Reserve Bank of India for smooth conduct of its affairs in carrying on business. Yet those are of regulatory measures to keep a check and provide guidelines and not a participatory dominance or control over the affairs of the company. Actually, this is the most vital part. A private company carrying on banking business as a scheduled bank cannot be termed as a company carrying on any public function or public duty. Normally, mandamus is issued to a public body or authority to compel it to perform some public duty cast upon it by some statute or statutory rule. In exceptional cases, a writ of mandamus or a writ in the nature of mandamus may issue to a private body, but only where public duty is cast upon such private body by a statute or statutory rule, and only to compel such body to perform its public duty. Merely because a statute or a rule having the force of a statute requires a company or some other body to do a particular thing, it does not possess the attribute of a statutory body. That is how Axis Bank will be not coming under mandamus direction. And your Lordship, this is this particular case. In our case also, Ombudsman appeal is pending, so alternative remedy is yet not exhausted. So that is how this case is not maintainable against Axis Bank.
Why did you debit freeze the account? What was the reason?
That is another story, your Lordship. We received 2 contradictory instruction from both the directors. Asked by director asked us not to give operation to a particular board resolution which inducted new directors. So new directors, new change of authorized signatories instruction.
Where is your stand? Is any document annexed to the writ petition from where your stand can be ascertained?
Lordship, they have annexed our letter.
Page 175. First volume.
This was the communication made, which they have also relied on. They have read this, and after that, we had made our stand very clear that since we are getting contradictory instruction, which one we should follow. So there is a dispute. There was a dispute. Now I came to know from here only that the dispute has been resolved. But I have to ask to my client because my instruction is it is yet there. So
would you like to take further instruction after going through the order that has been passed by NCLT and that has been placed in court today?
But if there is something else, because I have not submitted anything else, it is only the petition.
Page 1. Yes, in the petition only those documents are annexed. Page 175 is your letter.
It's an order. How can I dispute it? I'm not.
Right, you cannot dispute. Now, if the NCLT records that there is no dispute between the parties,
I have to follow it.
Then why don't you follow it?
One direction from your Lordship that open the account based on that order because there is no dispute, we will open it.
What is your stand with regard to the NCLT order? You have not challenged. You filed an application for intervention. Your application was not allowed.
Yes,
what remains?
If there is no further dispute, then it is matter resolved. Matter is resolved. On that fact, that is why I submitted before your lordship that on maintainability point, I am today I can submit, but
Are the disgruntled directors party over here?
No.
They are not parties.
I appear for the respond number 5.
You are supporting.
Yes, I just give you lordship 3 facts which may help here. Lord, I am the 100% shareholder of the petitioner before your lordship. Now your lordship will mark the words 100% shareholder. So Lord, if I am the 100% shareholder, there cannot be any shareholder dispute in that company.
This is where the issue is.
Now, I'll just give me 3 sentences. I won't take more than. So Lord, I am 100% shareholder. Now they went to the NCLT claiming they have a right. Now NCLT said you have wrongfully had it marked as management dispute. That's the order. That's not annexed here. I'll just give it to your lordship, saying that there is no management dispute. So after that, the writ petition was the petition before the NCLT was dismissed.
Right.
Now, along with that, naturally, the bank's application also goes along with it. So there is nothing left. They know it. Now, as a 100% shareholder, I am saying, look, no one can appoint a director other than with my consent. There has to be AGM, and I am not 100%, not even 96% that any other shareholder can dispute. Let me just show your lordship one para from the NCLT order.
Is it not annexed?
But,
well, we have only annexed the
final order.
The order of the larger bench, if I may use the word, the third bench.
The larger
third
bench upholds this.
Third member who upholds the dismissal order, because there was a divergent opinion in the Calcutta NCLT where one of the members have said it should be dismissed, the other member said it's maintenance. So it was referred. The third member said it should be dismissed.
Now, please come to para 15.24. On record, there was absolutely no action of any consequence, save and except that the ROC seems to have been cajoled into marking the subject companies as being under management dispute. This was chicanery on the part of the subject companies, since on 22nd April, there was no management dispute. This is the finding. The boards of the subject companies were united in their decision that VTL should not be allowed to have its way. What was there was 100% shareholder was attempting to infuse new directors on the board. Now, from here, please come to 14.26. 15.26, I'm sorry, at page 113. Now, please come to subpara D. On 9th February 2021, RP Singh, one of the directors of the subject company, objects to the passing of circular resolution holding there was no such meeting of the board of directors, although they had claimed it was held. He also states that all previous and subsequent meetings have been held upon prior notice and there was no notice only of the meeting of 20th December. This factual assertion remains uncontroverted or challenged in the petition. The inconvenience in addressing this issue is also evident from the fact that learned counsel for the petitioners brushes aside this issue as of no consequence. So, no answer could be given to this. Now, please come to 15.44.
Is any appeal pending before the NCLAT?
Appeal is pending.
Appeal pending.
May I just indicate
No
one thing?
stay.
Appeal is pending, no stay by the other sets who claimed to be directors.
Not just
Bank
that,
had filed, Axis Bank had filed an intervening application.
Axis
That
Bank has
aspect
not
is not challenged. So they cannot challenge it.
No.
Time is long gone.
Suppose Axis doesn't challenge, but the disgruntled members appeal before NCLAT
I am the only
is
member.
pending.
I am the only member.
Then who has filed the appeal?
Claiming to be directors.
My learned friend, they are not even claiming to be members. They are removed directors. They say you could not have removed me. Now see the finding on that.
I get it,
15.4.
but then it is pending. Now suppose the bank
There is
is
no stay.
directed, no stay. Suppose the bank is directed to defreeze the account.
Yes.
And in the meantime, the money gets wiped off.
I'll give an indemnity. I'll give an indemnity.
Take the responsibility.
I'll take the indemnity. I'm the please understand. I'm a public listed company having thousands of shareholders, including banks, mutual funds, public shareholders. These things reflect very badly on the company. Very badly. Not because these are now required to be reported on the stock exchange that my bank accounts have been frozen or my subsidiary, 100% subsidiaries bank accounts are frozen. I'll give an indemnity. No difficulty. Your lordship can record that. I will indemnify the bank.
Because my lord, there is no proceeding.
When do you think that the appeal can be disposed of by NCLAT?
But they are not interested. They are not interested. It will never, and the bank will not, and the bank will not keep saying that there is something pending for life, and I can't have a operational bank account. But it doesn't make sense.
Party in
It's a
that
February
appeal?
2023 order. It's more than 2 years, 2
NCLAT,
months.
you are a party.
Yes, I am a party.
Well, it's more than 2 years, 2 months. They have not moved any stay. 2 years, 2 months. The order is 2023 February.
But may I put it differently? May I put it differently? But my learned friend's objection was that they have an application pending.
The banks.
Yes, that not in the letters. That was the point. Now, there is nothing pending with regard to the bank account. A specific application was filed by the other side to stop all these acts, pursuant to the appointment of the new directors. That they never got relief. Now, this obviously can't carry on for life. If they choose not to move the appeal, the bank account can't be frozen for life, and the bank will benefit because they've got money there. So, the bank is happy. But a bank, please remember,
the
has
bank
no right
will
over.
benefit. You will get the benefit too. It is not that the bank will benefit.
It's a current account. It's a current account.
No. Current account.
We are not getting it.
Yes.
It's not a happy thing for us.
But let them take indemnity either from me or from them. If they want to say that, look, keep it frozen, then they must be willing to make it up to the bank, the ex-directors. I am saying I will make it up. If I give an indemnity that, look, if it is found that the money has to be returned, we'll do so.
But only two things before your lordship calls upon the respondents. First, on the ground that ROC has marked it a management dispute, bank has frozen. Then ROC has unmarked. We write this letter to the bank. Bank says, very well, but there is no order of court. Initially, they should have waited for an order of court. Now, and their sole basis is ROC marking it as management dispute. Now, once ROC has unmarked, then the bank should have then permitted the operation. And your lordship's court have, in umpteen number of cases, held that mere filing of appeal does not amount to stay. So it's 2 years, 2 months now that they have not got a stay.
But just one more para in that order, 15.44. I am the 100% director, shareholder. I can remove directors at whim without them complaining, and that is the finding here. 15.44
But then this goes without saying.
Yes. So, there can't be any management dispute here.
My lord, with regard to the
One
submission.
thing if there were two warring sets of shareholders. This is not that situation. This is not that
situation is that, but then yes.
My lord, with regard to the submission made so far by the learned senior counsel for the petitioner, with regard to the order or whatever the closure of complaint by the banking ombudsman, may I be heard out only limited to that, because my role is very limited regarding the complaint which was lodged.
Are you required to be heard?
Probably so, only because what has been shown or cited before your lordship is the decision in the Axis Bank and India Cable. Now that decision A is not applicable. Why? I'll just indicate. Here it was a case where the banking ombudsman had come to a finding that there is no banking deficiency in service. Now, with regard to the present case, the issue why it was not interfered with was because of the pendency of the litigation between the parties. That was the primary concern for which the complaint was closed under the banking ombudsman scheme. So that was not placed before your lordship. If your lordship will kindly look at page number 396.
I don't think that will be required. If an indemnity is filed,
that is then between the bank,
yes,
between the bank and the petitioner.
Then the bank's interest can also be protected.
Yes.
And the parties can
also withdraw the money.
Continue with their business.
There is no bank's interest. It's only skirmish between the removed directors and there's nothing else.
Whatever. The bank, some type of protection, security the bank also requires. Otherwise, the other party will sue the bank. That's why you have
no right.
permitted.
They have no right. They don't even have the
Right
minimum shareholding to make any complaint.
Right or not will be the ultimate relief that the court will grant. But in the meantime, the bank will be...
They are so not confident of their case that they have not moved in 2 years.
Please come. The petitioners are aggrieved by the act on the part of Axis Bank.
Could I have your lordship's leave notes?
in freezing their bank account, relying on a complaint lodged by complaint was lodged by August. Complaint was lodged by bank. Complaint was lodged by whom? By August? August. Only August.
Erstwhile directors, not August.
Erstwhile directors of August. By the erstwhile directors of August. In May 2021. Stop. The bank the bank also took note of the recording in the site of the registrar of companies dated 8th June 2021, mentioning that there was a management dispute between the directors of the company. Stop paragraph. The registrar of companies thereafter removed, demarked the recording of management dispute from the official website. Stop. After in website in July 2021. Stop. After removal of the said remark, the petitioners approached the bank with a request to defreeze the subject account, but the bank refused to change the freezing. Stop paragraph. It appears that the erstwhile directors approached the NCLT by filing CP number 112/KB/2021, which stood finally disposed of with a judgment passed by the referral bench of the National Company Law Tribunal at Ahmedabad by dismissing the company petitions. Stop. An intervening application was filed by Axis Bank, which also stood dismissed. Stop. It has been brought to the notice of the court that an appeal was preferred, not was, an appeal has been preferred before the appellate tribunal, but no order of stay has been passed, even after 2 years of filing the appeal. Stop paragraph. Prayer has been made by the petitioners seeking a direction upon the Axis Bank to defreeze the bank account. Paragraph. Learned advocate representing the bank raises a preliminary issue with regard to the maintainability of the writ petition. Paragraph. The Learned senior counsel representing the private respondent submits that the private respondent is the 100% shareholder of the petitioner. Stop. The private respondent is ready and willing to submit a bond of indemnity before the bank in respect of the bank account. Stop paragraph. Admittedly, as on date, there is no order passed by any judicial forum directing or permitting the bank to freeze the to debit freeze the bank account of the petitioner. Stop. On the contrary,
There is the issues are bank account as well as the demat account with Axis Bank. Both.
Achha, bank account and demat account. Of the petitioners. On the contrary, the remark by the registrar of companies regarding management dispute, relying on which the Axis Bank debit freezed the accounts of the petitioner, has been removed. Stop. Next. The intervening application filed by the bank before NCLT also stood dismissed. Stop. It appears that, as on date, there is no legal impediment on the part of the bank to defreeze the accounts of the petitioners. Stop. Next. The submission of the bank that the writ petition will not be maintainable cannot be accepted in the facts and circumstances of the instant case. Stop. The petitioners the petitioners have got a banking relationship with the Axis Bank, and the right to business is directly related to the operation of the bank account. Stop. If the bank account and the demat account of the petitioners are debit freezed by the Axis Bank unilaterally without any cogent reason, the fundamental right of the petitioners to carry on business gets infringed. The paragraph, as the pro forma respondent has accepted to provide an indemnity bond in respect of the accounts held in the Axis Bank. Accordingly, the Axis Bank is directed to permit the petitioners to defreeze the bank account and the demat account of the petitioners, subject to depositing an indemnity bond as per the norms of the bank. Stop. Next. The steps shall be taken in the matter at the earliest, but positively within a period of 4 weeks from the date of communication of this order. The writ petition stands disposed of. Please take back all these.
Only two things.
Yes.
They have a right to take, because we may have to claim compensation against the bank for the 3 years we couldn't operate the account. Kindly preserve all other rights.
That you can obtain in a suit.
Yes, suit. So the Logic kindly preserve all the rights of the parties in other proceedings.
If they have it.
But even if it is not recorded, it is open to you.
So, well, there may be a question that I could have claimed damages because technically in writ petition one can also claim damages.
As regards the prayer of the petitioner claiming damages from the bank for not permitting the petitioners to operate the bank account, causing loss to the company, it will be open for the petitioners to approach the competent forum for remedy.
With the leave of my learned senior, only one small correction possibly. Your lordship has mentioned CP number 112.
That will not be the number.
No, that is 113. Because there are three matters, items 12, 13, and 14 in my lord's list. One is August. So far as companies' names are different in respect of the three CP numbers. Your lordship has mentioned August in this order, in the third paragraph possibly.
Yes.
So the next matter would be Insilco, and the one after that is Laneseda.
And all is Axis Bank.
All is Axis. Rest of the order can remain the same.
And the
I'll
CP
only hand
numbers
up.
will change.
Yes, I'll only hand up a slip with the item numbers, the name of the petition, and also the CP number, which should be the.
Please. Same order change হবে না
But may I file the affidavits of service?
আগস্টের জায়গায় অন্য দুটো হবে দুটো মামলাতে আর সিপি নাম্বারটা চেঞ্জ হবে ওনারা দিয়ে দেবেন স্লিপ তাহলে দেখে আপনি বসিয়ে দিতে পারবেন what is it
The affidavit of service.
yes affidavit of service taken on record
There is only one affidavit of service in the first matter, the others.
but then the others are represented so no issues
Yes. Well, I'll just indicate to my lord's officers.
I am very one clear of the respondent number 1 and 2.
For the petitioner, Mano. The last occasion, you are also directed to inform the state respondent. State name. Here is the affidavit.
state is appearing
No, my lord, I am for the
Not
respondent.
with him. The last occasion, you will please to direct to have the notice upon the state.
who is appearing who is
We
the
have done
learned-
it.
who is the learned counsel
That we don't know yet.
no you must be knowing otherwise who did you serve
The Register of Cooperative Societies and to the Assistant Register of Cooperative Societies. Normally, Mr. Naik or Mr. Roy appears, we inform them also verbally. The notice for a page, and notice has been received, but today there is a resolution. Yes, your lordship.
yes so what to do I'll make it only not today
Fix
Only
it day
not
after
today.
tomorrow, my lord. Tomorrow I have some personal duty. Fix it day after tomorrow.
none appears for the state despite service affidavit of service is taken on record list the matter day after tomorrow 11th
Deeply obsessed. 6, 7, 6.
আচ্ছা একটা লাইন লিখে দেবেন তো the presence of the state is very vital for the effective disposal of the instant writ petition 16
Lordship, about the petition, Lordship. Lordship, actually what happened?
are you there
Yes.
yes
Lordship, I am exempted from submission of EMD and other security deposit because I am MSE
MSE.
unit and other the Uttam has been issued in favor of me and I am also enlisted in the railway panel as exempted category, Lordship. Lordship, all on a sudden, Lordship, authority, respondent number 2, Lordship.
who are you
Lordship, I am a Union of India. For the respondents. Lordship, page 23.
yes
Due to withdrawal of offer by Messrs. Atul Engineering Udyog Private Limited, that is petitioner, Agra against tender number such and such opened on 5/12/2024. It is requested to debar Messrs. Atul Engineering Udyog Private Agra of exemption of submission of bid security EMD SD for a period of 6 months as per Annex A bid security declaration. Lordship, Lordship, what happened, Lordship? I have participated in a tender. Wrongly, I have quoted rate.
wrongly
I quoted rate wrongly. Wrongly.
right
They have asked me whether you want to continue or not.
You withdrew.
I withdrew. Thereafter, this notice, Lordship. And Lordship, most unfortunate thing is
And
that
at what stage did you withdraw?
Lordship, technical bid was supposed to open after that.
Prior to opening
Not-
of the
they
technical
have not
bid?
suffered any loss. They have opened the technical bid, financial bid, issued the work order. Everything has been done. Everything has been done. Lordship, kindly turn page next. Lordship, kindly turn the letter of the railway.
Lordship, after the getting the
I'll hear you, please. Yes.
Lordship, the letter they have asked for. Let's one to page 37.
Yes.
I'm sorry, Lordship, it's not 37, Lordship.
52.
52, Lordship. This is the letter. Confirmation of supply of high tensile transaction CB coupler to operated. This office has floated a tender for the procurement of such and such. This is second paragraph. As per BLB vendor directive, the status of your firm is reflecting as a developmental vendor, and as per our record, you have supplied only 39 numbers, including the prototype of high tensile transaction CB coupler without draft gear. In this regard, this office seeks confirmation of supply of subject item, that is high tensile transaction CB coupler top ordered against the above tender. Only that for the above tender. If form is found technically suitable for placement of order. That means report opening technically. A line of satisfactory reply should reach this office immediately after the receipt of this letter to facilitate the financial upload on the order. Next page, my reply. Please refer to the above mentioned tender and our bid. By mistake, we have quoted for 1 numbers coupler, whereas the tender is for 2 numbers per set. Earlier, all tender used to be for 1 numbers only. Therefore, our staff made this mistake. We request you kindly disregard our brief for our bid for this tender. Lordship, this is the actual thing, Lordship. And Lordship, without issuing any show cause notice, they have imposed punishment, Lordship. I'm a medium enterprise. Without these facilities, I cannot participate, Lordship. And this is a punishment without giving any opportunity, without hearing. Lordship, I am relying on judgment, Lordship, of the Supreme Court. Lordship, not on exemption, Lordship, but it is blacklisting. The Supreme Court has categorically stated not only show cause, detailed things has to be mentioned in the show.
All right, let me hear.
Page 34.
Mm-hmm.
Page 34.
Lordship, I'm going on the page, his petition 34.
Yes.
A declaration wherein
He himself filed a declaration that I should be debarred by the 6 months.
it's part of the tender.
And this is a part of a tender. After obtaining that, successful bidder, he has obtaining the tender, and when the workout was given them, it is found that they have withdrawn, that they have quoted by mistake. After that, I have to again float another tender, and he has also participated in that. We are this is a mercy writ petition before your Lordship, that he himself saying that I should be debarred for 6 months. Again, he has come before your Lordship.
No, what is this page 34?
Lordship,
Last 5 lines. We shall be debarred from exemption. Last 5 lines.
the last
5 lines.
5 lines.
We shall be
We shall be debarred from exemption of submitting bid, security, earnest money, deposit and performance, and security deposit for a period of 6 months from the date of IVR declared disqualified from the exemption from the submission of the EMD SD for all tenders.
Yes, but then prior to declaration, will you not give him an opportunity of hearing?
He had given a
He has given the opportunity, he has successfully got the tender, and after that we have their mistake. They himself said that by mistake I have quoted. So that's why I have incurred the expenses for the second tender. And second tender is also.
Was he the only bidder?
It was the L1.
Only one bidder.
L1.
Only one bidder?
The L1.
L1. So technical bid was not open at that time. How I have withdrawn? Lordship, they are documents.
The bid document. Where is the bid document?
Lordship, bid documents. It's not.
Lordship,
Lordship, page 52. Lordship, specific.
Page 52.
So we have to face the expenses incurred for the second
Lordship,
no,
why was a second tender required to be
because he has withdrawn. So I have to tender another float another tender.
L1, if he
Lordship,
withdraws, then we have
last
to-
but not least, then he has withdrawn from the L1, so I have to float another tender.
Why the L2?
No, this is the CVC guidelines.
As per our guideline.
CVC guidelines.
What your guideline?
The Ministry of Finance guidelines.
Let her to say.
The bidder who
Lordship, page
has
52,
found
Lordship,
to
can
be
you see?
Page 52.
Last but not in this regard,
Hmm.
the office seeks confirmation of supply of subject item that is high tensile such and such against the above tender. If your firm is found technically suitable for placement of order, if you are found in future technically, so before opening technical bid, I have stated on that same date, Lordship.
Yeah, give me the bid date. Bid date.
Lordship, bid date 5/12/2024.
5/12/24.
Lordship.
And you participated.
Lordship.
3/12/24.
Lordship.
And this letter is dated 18/12.
12.
In the meantime, technical bid did not take
No,
place.
their abandonment. Their abandonment. If your firm is found technical suitable for placement of order. So technical bid was not open. And last line, a line of satisfied eclipse should return to the office immediately after the receipt of this letter of finalize of the above letter.
What is this page 34 that they are relying 23/12/19? It must be in respect of some other contract.
Lordship, actually, Lordship, in all each and every contract, Lordship, I have covered that also. There is a clause that if I found.
Yes, that is in general.
In general declaration.
This
is a part and parcel in general declaration, Lordship.
Lordship,
Show cause notice
Lordship,
mandatory.
he has signed.
Page of
Sir,
this-
third page.
General declaration this is.
In page of the documents that have been given.
Prior to passing the order of debarment, did you grant any opportunity of hearing?
No.
Any show cause notice, anything?
Lordship, I have given one affidavit, Lordship, lying with on the record.
Second page.
The second page, please, second page.
I have not served anything.
This is your documents.
I have served.
Second, securing declaration to be signed by bidders.
By the petitioner.
This is signed by Atul. The signature stamp is there. Atul Singh.
The stamp, the official seal is there, signature is
Yes.
there.
No, but then no opportunity granted. This signing will
No,
not do.
opportunity given.
Where is it?
Already first tender has been given and already is participated in that tender.
For this same work.
Debarment order. Has any opportunity been given?
Lordship be given.
Where?
So we require some instruction from the department. Just give that some times. Just yesterday we have received this.
Please come.
Copy.
Lordship, till that, Lordship, kindly stay the operation of this.
No, I'm posing that.
Because there is no show cause notice.
Petitioner is aggrieved by the order of debarment passed
Given a reply, we
without
have considered and we have rejected
granting
the
any
page 53.
opportunity of hearing
What is in copy?
or without issuance of any show cause notice.
Given his reply, we have
Stop
considered
paragraph.
57, we have rejected. 27th February.
अच्छा order of debarment के date का दिन तो 1st January 2025. Is it 1st or 7th? ना पहले तारीख ही होगा 1st January 2025.
1st January.
Learned advocate representing the railways submits upon instruction that due opportunity was given to the petitioners prior to passing the order of debarment. Step. The answering respondent is directed to file a report by way of affidavit disclosing the steps taken prior to issuance of the order of debarment. Such affidavit shall be prepared and circulated by 25th of April, released on 7th May. Exception to the affidavit may be filed by the petitioner prior to the adjourned date.
Lordship.
Keep this.
Lordship, till date, Lordship, no, not to give further effect of
It
this.
cannot be done.
Lordship, there is so many tenders, Lordship, I cannot participate, Lordship. I have a
Please.
medium enterprise, Lordship. I have already exhausted to participate few tenders, Lordship.
Please wait.
Lordship, then I'm grateful, Lord. Because, Lordship, there is no show cause because they have got enough time, Lordship, to get that instruction. Now they are saying that the instruction 1 day, 10 days has lapsed, Lordship, after mentioning. So now they are saying this, Lordship.
Yes.
I'm for the respondent bank.
What facts of the case is this, Lord? Lord, the patient
My Lord, I am for the respondent number 7. My Lord.
Only 7.
Only 7.
8, 9, 10.
No, I am for the 7, my Lord. Before
You
my
are
learned
7. You are for the bank.
I'm for
Gramin
number 3, 5 and 6.
Bongyo Gramin Vikash Bank. And you are for the state. What is the issue?
My Lord, before my learned friend starts, my Lord, I place, my Lord, the one of the decision of this honorable court, which my learned friend, my Lord, has availed. I moved a writ application. Both the petitions are, my Lord, self-same cause of action.
Not the same
I am.
cause of.
Both means where is the other
My
petition?
Lord, kindly have a look. That is why, my Lord, I am drawing your Lordship's kind attention at page 110. My Lord, these two petitions, my Lord, can be heard together.
All right.
Kindly see.
100
Admittedly, in my petition, I did not make him as a party. Then challenging that order went up to the division bench. My Lord, division bench order, page 110. Lordship, kindly have a look.
Yes.
What the division bench says.
Setting aside and restoring the writ petition to the file. Where is that
Restoring the
matter?
writ petition to file of
Where
the
is that matter?
That matter, my Lord, let both the matter be tagged together.
All
Your
right.
Lordship, kindly, there was a direction for also filing of affidavits. No affidavits has been given.
Lord, this way my writ petition shall become in
Yes. I will take, my Lord. I am taking the maintainability of this writ
Yes,
petition.
Lord.
Let this writ petition be, my Lord.
Allow me to submit my case, Lord. I am the petitioner. Lord, admittedly, the petitioner is an owner of an immovable property. She received the property by way of the gift from his son. This is admitted position. Lord, I inducted the Bongyo Gramin Vikas Bank as a licensee in my premises. There is a lessee and lessor's relation. This document is also annexed with my writ petition. Lord, I was realizing the rent from the Bongyo Gramin Vikas Bank. There was no issue. Lord, so far as the respondent, private respondent number 5 is concerned, 7 is concerned, Mazhar Ali, who is represented by my learned friend, he procured a manufactured, fabricated deed, sale deed, allegedly executed by me. Lord, then I, being a plaintiff, filed a suit against the Mazhar Ali before the competent court of law. Their bank was not party for setting aside that sale deed. There, upon contested hearing, I got an order of injunction from the competent court of law. Then, Lord, Mazhar Ali, feeling aggrieved with that order, preferred and challenged appeal before this honorable court division bench. Then, Lord, the honorable division bench set aside the order and remanded matter before the trial court for further hearing of the injunction application. In the meantime, directed my learned friend client not to transfer the property in favor of anyone else. This order was, then second application was filed for modification of that order of the division bench. Application was rejected with cost of rupees 50,000. That order I have annexed. Then, Lord, very surprisingly, how the fraud was committed upon this honorable court. What he has done, after disposal of the matter before the division bench, he filed a writ petition in a residuary jurisdiction, where I was not made a party. All the previous fact regarding order of injunction, etc., was not disclosed. And Lord, my Lord Justice Sarkar was kept in dark. And Lord, an order was procured from the my Lord Justice Sarkar, Sampar Sarkar, directing the bank to pay entire rent in favor of Mazhar Ali on the basis of that fake deed. And the Honorable Justice Sarkar has held the further course of action will abide by any decision of the civil court if it is instituted in future. My Lord Justice was not informed, even the civil court matter is pending. Then, Lord, I feeling aggrieved, preferred an appeal before the division bench with leave to appeal. Then, Lord, before starting anything, he gave the concession before the Honorable Division Bench for setting aside. Lord, the Honorable Justice set aside this, Honorable Division Bench set aside this order. Now, Lord, the situation is this: the bank is leaving my premises.
Bank is
leaving my premises.
All right.
Bank is no more interested to keep the relation with me as a landlord tenant. Now he intends to surrender the premises. The question is that, Lord, whether I am entitled to get the rent, or Lord, he will act upon the fabricated deed.
Is the bank still in possession?
Bank, the law, under lock and key is in the possession of the bank. So that is why, Lord, I prayed, filed a representation before the bank to submit the key, or the key should be handed over to the register. I don't have any problem, Lord. Let it be deposited with the register.
My lord,
and the all area rent should be deposited with the register. And that the outcome of the decision, who will take the rent or the key, that will depends upon the outcome of the civil courts.
Tell me, who inducted the bank as
me, my lord. This is my documents.
Lessee, you were the lessor.
Yes, I am showing the documents, Lord.
All right. No, you don't have to show.
Submit on behalf of the.
Kindly come to, Lord.
You do not have anything to say.
Yes, my lord.
What?
First of all, on technicality point, this writ is not maintainable. Kindly peruse the prayers. All of civil jurisdiction prayer. One is direction of mandamus to surrender. One is to collect the area rent.
Are you paying the rent?
My lord.
Are you paying the rent?
This time, due to an order passed by the learned trial court, the rent is depositing in a
Lord, this
account, separate account.
Where?
In our bank.
You are maintaining an account in your bank where you are depositing rent. In whose name?
Let's seize the order.
There was a sundry account separately open just to keep the rent in the custody.
Not in anybody's name. Particular name you have not kept the money.
No, my lord. As per the direction will passed by the learned trial court, we will pay the amount to the person.
You will pay, but then as on date,
no,
there is no account in favor of either of the parties where you are paying rent.
No.
But you have kept some amount separate on account of rent.
Yes.
Right? You do not have anything to say with regard to who will get the rent and anything else.
No.
You are nobody.
No.
Right? From whom did you take the subject land? From
page
the
25.
petitioner.
From the petition.
Right?
Page 25, Lord.
Page 25.
My lord.
All right, I followed it. What is your submission?
Now, my lord, what my learned friend has not submitted, this matter went up to the Supreme Court.
Yes.
Then Supreme Court, my lord, what the cost was, my lord, awarded, that was, my lord, Supreme Court set aside. The matter is pending before the civil court. Now, my lord, what I am praying on, subject to your lordship's kind consideration, let my writ petition and this writ petition, both the writ petition tagged together, let it be heard by your lordship any day. Any day. Because I have some cause of action. He is saying by forged, I have registered the deed. My lord, I am putting this question myself. Before the register, he attended there, he put his signature. This is forged. What happened if I...
No, but then the suit is pending.
My lord, I am telling what happened. The petitioner is the mother of a Nikhil Ranjan Bishwas. My lord, if I open the mouth, my lord, he will be in great difficulty.
No,
my lord, what happened? He has taken crores of money. And this, my lord, this writ petition given undertaking that unless with a certain date I cannot repay your entire money, I shall hand over my property to in your name.
And that is the way the property got transferred.
Yes. Now he is claiming, my lord, it is a forged document. I have that document. My lord, let both the matter become, my lord, tagged together.
Very well, please.
Lord, the Nikhil Ranjan Bishwas.
Yes, I shall. Don't force me to open my mouth.
That does
he
not
will be in great difficulty.
That does not give the license.
Yes, I shall understand.
My property.
I shall understand. You understand.
WP number let WPA 17823 of 2024 appear along with the instant writ petition for further consideration on 22nd of April. Affidavit of
today is,
service filed in court is
my
taken on
lord,
record.
only one indulgence I am praying subject to your lordship's kind consideration. My lord, I want to use an supplementary affidavit, what his son has done and what she done.
In your writ petition.
Yes, yes, my
Let
lord.
you prepare it, but since your file is not here, I cannot pass
Yes,
any
yes,
order.
yes, sir. Yes, yes.
Next.
I brought the petitioner, respondent.
Yes.
My lord, in this matter, I have challenged the order banning or blacklisting the petitioner company from participating in the business of the companies of the sale. But because I said I have also preferred an appeal. Appeal is pending. I cannot because the departmental appeal. But my point is that if you also can come to pace.
If appeal is pending, let a direction be passed to dispose of the appeal.
Yes, you also, but I want to make out one point. If not, can you allow me? You also can
Will
come
it
to
be
pace.
required?
Yes,
The point, I do not know what point you will take, but
No,
then if the appeal is pending.
It is, it may be kindly your findings are required. I just can come to page 94.
Page?
94, the order.
94.
My lord.
Yes.
Your my company is a Yukon Enterprise. Your organization had participated as consortium with M because being the leader of the consortium, attending process and for technical eligibility. Yukon, my company, has submitted manufacturer authorization certificate from MM issued by the Sachinder Electron. And during preliminary technical evaluation of investigation, it was found that the concerned Yukon Enterprise, my company, who is a partner, the member of the consortium, had submitted fake and fraudulent document along with the bid documents with respect to tender inquiry endorsed by M because the response 8. Now can you have the findings, board's fifth paragraph, based on the available facts. Got it, my lord?
Yes.
Fact, standard banning committee of business dealing has concluded that this consortium of M because the 8, you can resorted to submission of forged documents and recommended for company-wide banning. So both of us have been penalized. My lord, it's a consortium. You must kindly come to page for a moment, page 38. Is a
Yes.
And can you see the consortium bidding? What is a yes, that you got it, madam? So consortium bidding, maximum 3 consortium members, including consortium leaders, are permitted. 3 members. Now you also can come to page 47.
Yes.
But the technical criteria can is 2 below. In case of bidder in a is in a consortium, one or more of the consortium members, a maximum 3 consortium members are permitted, can either individually or together fulfill the criteria as mentioned in the clause 1. Next one can come to page. The responsibility of the leader of consortium should be member having maximum job. Bidder has to submit notarized company copy of memorandum of agreement. But I'm disputing. I've not made any consortium. This memorandum agreement is executed, at least executed by them, not my signature. So no consortium has been found by me with this M because this but I'm not going to this dispute. Suppose I didn't. My point is that
you are not going to this dispute.
No, now at this I said that in my so-called that I've never entered into any memorandum agreement with him.
Was your participation an independent and an individual participation?
No, I've never participated. I've been
never participated in the bid or tender or whatever.
I've been made as a member of the consortium by the M because
without your knowledge.
No, nothing. But this agreement, he has produced the agreement as this is my fourth signature. But I'm not.
That means you did not know about the existence of your name in the consortium.
The Shokos notice, I have replied Shokos, I have taken this point. Now I've taken another point. You also can come to page 37. Roman 12. In case of consortium bidding, only one member of the consortium shall be provided user ID and password for submission of bid on behalf of the consortium. My point is that they should determine to whom they have provided this ID, user ID and password.
So that they will do, that is their part. But what is your stand? You are not a member of the
I am not the my reply. Can you see my reply? Yes.
What did the adjudicating authority hold?
Page 79. That has not been considered. That has not been considered.
That has not been considered.
No. They said both of you. You are the member of the consortium. Because
so it was considered, and they thought that you were they were of the opinion that you were a member of the consortium.
They said I am because the leader because that's why it produced a memorandum agreement in support of the consortium. I said
you say signature is false.
False. Can see my reply, my lord. Now I'm not.
Now tell me one thing: how will the authority get to know whether your signature is false or not? This is an absolute under the domain of the police.
Yes,
let them go and find out.
This is what is going on. Now what I point has been taken because see, we are in the constitution. One member should get the ID and password. He has the only authority to having the access to upload if they in a forged document. But that should be determined by them. They have given to me or they have given to the because that is the point. If it is given to M because he's a leader, then I have no access. So I'm not going to the question of
thing is whether you have an access and no access. If you are a part of the consortium, then everything you will be liable.
No, my lord, page 37 is very clear. It will be given to one. It will be given to one, my lord. Can you see? That should be determined by them. They have given. Now, your lordship can see. We are the four members.
Show me the order of the adjudicating authority.
At page 94.
94.
Based on the available facts, Standard Banning Committee for Business Dealing has concluded that the consortium M because and UCON resorted to submission of the forged document and recommended for company-wide banning.
What will the writ court do?
Well, my point is that in the appeal, this point can allow me to take this point. In the appeal, I have not taken this point.
You have not taken this point?
In the appeal, I said that I am not executed this memorandum agreement.
You have mentioned.
This is, but this point which I raised before Lordship, my lord, they should determine any of the members could get it.
But then everybody will be liable.
No.
How can you shrug off your responsibility and liability?
Sorry, madam. Page 37. It's very clear.
Yes.
In a consortium meeting, only one member.
They cannot provide it to three, so they'll provide it to one. You will be the leader, and
I'm not the leader. Leader is the M because.
Whoever. Now, leader will be responsible for all,
but
and
that should be
everybody will be
liable.
liable.
You also can appreciate that it is, my lord, in the
consortium means a group.
It's a group. But here, my sister, they said I will give you one of the members. This is why I'm.
No.
I know that, my lord, I am not. I have taken this one. This is a force. I'm informed. Raurkela, there's a Delhi company. I'm not executed. All points I've taken the reply. Can you see my reply at page 79?
79.
You should put me a question. I have filed a criminal case that I have not filed.
Obviously,
I know.
If you allege fraud, your signature is forged.
I should file a criminal case.
Did you lodge a police complaint? Nothing.
I just did the reply. What happened when this show is given? The MBK sent me the copy of this agreement.
Why will MBK send you if you do not have any relationship with MBKs?
No, only to save themselves. I said
save themselves.
Consider.
How did you get in touch with MBKs?
There's no connection.
No connection.
No connection. There's no connection.
There are so many people around.
I'm from Raurkela. They are from Delhi. I have no connection, my lord.
How did MBKs find you?
But I can't say much more legally because I should file a criminal case. That I know. But my reply can see.
Page 79?
Yes.
Very well. Where is your appeal? Show me.
Appeal is pending.
Page
102.
102. Please come. The petitioner has been debarred by sale from participating in any of the tenders slash business dealing. Stop. Next. The appeal preferred by the petitioner before the chairman, sale is pending consideration. Stop. Paragraph. The petitioner submits that the reply to the show cause filed by the petitioner on 24th of July 2024 may also be taken into consideration at the time of consideration of the appeal. Stop. Paragraph. The paragraph, as it appears that the petitioner has raised his grievances before the appellate forum, accordingly, the instant writ petition is disposed of by directing the chairman, Steel Authority of India Limited, to consider and dispose of the appeal preferred by the petitioner in accordance with law at the earliest. Step. At the time of consideration of the appeal, the reply to the show cause filed by the petitioner before the general manager within bracket EM sale dated 24th July 2024 shall also be taken up for consideration. Writ petition disposed.
Additional points may be taken. And the point is
How many additional points? Your show cause reply is all. You cannot take new points at the stage of appeal.
These are determination.
New points in the stage of appeal, nothing. Call the next matter.
Grateful. Yes, madam. My lord, division bench did not accept
Which one?
that those tender matters.
Did not accept. So the other matters follow.
So 11 I might junior. Yes, ma'am. Great.
দেখো যা আছে
Invoked for block 3 of last two orders of your lordship is very good. So 24-2.
your other side is not here.
Question has been made very well clear. The Honorable Supreme Court in the Justice Debarment judgment. What they should do actually and what they can do.
Did you implead the purchaser? Did you implead the auction purchaser?
Yes. Yeah, this.
Serve. देखिए सर्विस देखिए
करो कभी दीजिए ऑप्शन पॉइंट से तो what is it? Can I excuse my impertinence? America says one very, very nice discussion is there.
No, but then I want your other side to be present, the bank.
That's right.
Just make a phone call. I'm passing it over. Make a phone call.
Phone call phone number jano tumhe
Are you aware of the phone number? এই আমাদের ওকালতনামাতে ফোন নাম্বার দেওয়া আছে দেখুন তো ওকালতনামা ফাইল করেছে
Nowadays every phone number is there in every outside. তখন আজ ফোন আছে কিনা না জানি হ্যাঁ বলছো কেন
Miss Joyita Ray and Subhash Chandra Sarkar. Anybody's phone number is there?
Last two occasions they are there.
ওকালতনামাটা ওকালতনামা দিয়েছে তো It has been filed. ও আচ্ছা হ্যাঁ ওকালতনামা has been filed. Is there? Please make a phone call. I'm just passing it over. Call the next matter. It is here. You get him. I'll do it just now. 59.
59 and 60, my lord.
Yes.
Hearing for the petition, I am led by Mr. Kamlesh Bhattacharjee.
Yes.
Lord, my senior is appearing all through online. Lord.
Please, your lordship, I am appearing for the bank.
Yes, yes.
Lord, we are submitting the exception to the report filed by the bank. In this matter, my lord, the bank has taken possession of my flat on the pretext that those are mortgaged with the bank, but the flat numbers are completely different. In a flat building, which is having 2 flats in each floor. In that building, the bank has allegedly taken possession of flat number
3B and 3D.
3D, my lord.
Yes.
The search report, the bank has with the direction from my lord, bank has filed a report, search report, that shows that the relevant at the search report which has been forwarded, that shows, my lord, the relevant search has not been conducted. Due diligence has not been done properly. Kindly takes a page number 12 of the report filed by the bank.
Yes.
Is the page number 13, I'm relying column 5, which says C, he has verified the title of the property with the additional register of assurance to Kolkata up to 2015. My conveyance was registered in at ARA 3 Kolkata in 2021. The completion certificate is also they have given in page number 15, point E on the right hand side, that CC serial number 721.
Page number 15.
Page number 15.
Yes.
CC serial number 721 14/15 dated 15th July 2014, issued by the Rajarhat Gopalpur Municipal.
I didn't get it. Which portion?
Point number E.
Point number E. Sanction plan.
On the remarks column.
Remarks column. Yes. Wide sanction plan.
PP. Yes. Serial number 212/1112 dated such and such. CC completion certificate. Serial number 721/1415 dated 15th of July 2014 issued. This was issued in 2014 and they have conducted search, which is appearing at till 2015 only. My conveyance, which is annexed with the writ petition, starts 19744 writ petition is my lord is taking up.
Yes.
Page number 17 is my conveyance. Shows that it has been registered with the ARA 3, additional register of assurance 3, on
2021.
2021.
From whom did you purchase?
From the developer.
From the developer.
Developer appeared before your lordship and confirmed that there is no flat 3D and 2D, which is recorded in your lordship's order.
Yes.
Dated 20th of January 2015.
Tell me whether the dates which are mentioned at page 13 and 15 are proper or not. The CC, was it given on the said date?
CC, my lord.
15. You have purchased in 21.
21.
That means at that point of time the CC was there?
CC was there. Should have been there.
If this is the correct date. And when was the loan given?
Loan sanction after my purchase, one month from after my purchase. The sanction letter has also been annexed by the bank in their report.
Page?
Which is at page 7, annexure A. It's 27th of August 2021. And my conveyance was of 27th of July 2021.
For the Canara Bank, perhaps my learned friend has not gone into what they have written in their own writ petition, Millet. We say that there are two different flats. Now, from their own exception to my affidavit, Millet, they cannot prove on the last occasion we submitted that they were never in possession, which they are claiming that that flat was in their possession. They were never dispossessed through an order of the learned DM, Millet.
They were dispossessed.
They were never dispossessed. They were never in possession, Millet. We say that there was someone else who has obtained loan where we have conducted from our opposition, Millet, not opposition, the report which was we were given opportunity to file. We have shown the photographs, the geolocation also inside the flat, Millet. They were never in possession of the flat.
Tell me one thing, your sanction letter, which has been shown just now, page 7 of your report, is
My lord.
dated 27th of August 21.
My lord.
Now, page 13 has been shown where the title deeds were verified till 2015. Not till, it is 2015 onwards.
ARA 2 up to 2015.
Yes, ARA 2 up to 2015.
My lord.
You sanction a loan in 21 and you make such till 2015. Why?
Millet, as far as that report is concerned, Millet, what they are showing, Millet, that is currently not in my hand, Millet, not in front of me.
It is annexed to your report.
Millet, it is annexed to your report. It's my report, Millet. Millet, I just have to see that document because till the date when the loan was sanctioned, Millet, we have done the entire search.
Where is it? Your document doesn't show.
Millet, kindly, Millet, that document is not in front of me right now, Millet. For some personal difficulty, Millet, I could not come to court today, Millet. But the entire, on the last occasion, Millet, I showed to your lordship that the entire exercise of how we have advanced the loan to a person, they were not the petitioner is not the authority, Millet, not the person to which we have granted the loan. It's someone else. Till now, they could not show that how the flat which we have taken, Millet, it's the same flat from which they are claiming their title, Millet. Even the photographs,
The developer says that no such flat exists. First,
Millet,
second
only
is,
on the first occasion, Millet, the developer appeared, Millet. From that day onwards, the developer has never appeared before your lordship, Millet.
Why will the developer appear? There is no requirement of the developer. The developer
Certainly, Millet. Even there are criminal cases filed against the developer also.
Yes. Let the criminal cases proceed in
Certainly,
accordance
Millet.
with law.
That is there.
With this. But how? What has the bank done? They have locked it or taken possession?
Millet, we have taken possession, Millet. We have taken possession of the premises, but they were never in possession. It's not their
Who was
case.
in possession. Thing is whether you have any right to take possession of somebody else's property or not.
Millet, we have, it's our case
I'll
that
make
we
it
have.
not today only.
My lord, certainly, my lord.
Did you file something today?
Yes, my lord. I have filed the exception to the
Exception to our report, Millet, we have received it.
exception filed by the petitioner to the report filed by the bank is taken on record.
Copy has been served.
On the prayer of the learned advocate for the bank, hearing stands adjourned for the day. Tomorrow it will appear in the supplementary list.
Much obliged.
দুটো আছে দেখুন, দুটো মামলায় হবে মনে হচ্ছে।
And for the state laws.
Record your appearance, dismiss for default.
Yet. The last occasion, the report has been submitted, that is kept in record.
If it is there, it is there.
Yes, I am for the petitioner, my lord.
Yes, what is the matter?
State was directed to file a report. I don't get the report yet.
Last occasion, we have filed one report, my lord. After that, I elaborate report.
Last occasion, you have filed a report.
Regard to the assessment of the compensation of the damage alleged by the petitioner.
My lord, 1,50,000.
My lord, petitioner was a victim of the postful
is the report.
violence. Postful violence and unspeakable atrocities has been perpetrated upon him, and he was not now in his own house. His house has been demolished. Everything has gone. His only offense, let alone offense, it is only seen that he is a member of the
Opposition.
opposition. His only sin is that. And now I just got the report, my lord, from my learned friend that we will file definitely the exceptions.
Go through it and come back. A report filed on behalf of the district magistrate, South 24 Parganas. Dated 6th March 2025. On behalf of by the district magistrate. Because it is taken on record. Copy of the same handed over to the learned advocate for the petitioner in court today. Stop. Released on 6th of May.
Obliged.
63.
Yeah, I am the petitioner, my lord. I am agreed by the notice dated 15th March 2000 at page 13, my lord.
Do you intend to file an objection, exception to the report?
I can find the report objection. Because they sold the property, conveyance has been done, but executed in favor of the purchaser.
They have restored the property?
Yes, my lord. They sold the property in
sold?
Yes, my lord. 2021, conveyance has been executed in favor of the auction purchaser.
Yes.
So notice
Who are you?
I am the borrower.
Challenge the sale.
I am not going to challenge them. Let they sell the property, I am not going to challenge the sale, my lord.
Why have you filed the writ petition?
Because
What
they
is
issued
the
the notice at page 15, page 13. Can you turn to page 13?
Page 13.
They issued the notice to me when the property has been sold out, had nothing to do with me.
But they say that the sale did not take place.
The convention there is, they stated in my
In the report, they have stated.
Yes, certificate is issued, my lord. Page 6, page 3, paragraph 6 of the report. As is very basic, they sold it to me. Paragraph 6, page 3.
There is no report on record. Report must have been given to you. I do not have a report.
May I note?
Yes, just give me.
They have given the report to me. No.
I mentioned what 68.
Please come. None appears on behalf of the bank. Stop. The petitioner as borrower failed to repay the loan amount for which the secured asset was put up for sale, and on confirmation of the sale certificate was issued by the bank on 19th of February 2021. Stop.
And deed of conveyance was executed on 11th November 2022, my lord.
What? Conveyance?
Yeah, 18 November 2022.
What?
Conveyance.
Where is it?
That is stated in paragraph, my lord. Paragraph 4 of my petition, my lord.
The petitioner has averred in the writ petition that a deed of conveyance was executed by the bank in favor of the auction purchaser, and the said deed was registered in the year 2022. Stop. Paragraph. You are not in possession?
No, my lord.
The petitioner, the learned advocate for the petitioner asserts that the petitioner is no longer in possession of the secured asset. Stop. He is aggrieved as a notice, as a copy of the notice dated 15th March 2024 was communicated to him by the District Magistrate South 24 Parganas, mentioning that an authorized officer has been engaged to take possession of the secured asset. Stop. The petitioner submits that as the petitioner is no longer in possession of the secured asset, accordingly, the notice ought not to have been served upon him. Paragraph. From the report which was forwarded by the learned advocate representing the bank to the learned advocate representing the petitioner, it appears that the sale took place without handing over of the physical possession. Stop. Because of the restrictions imposed during COVID-19 pandemic, the bank could not take possession of the secured asset. Stop. By the impugned communication, the district magistrate appointed an executive magistrate to oversee and execute the possession order. Paragraph. Next. As the petitioner claims that he is not in possession of the secured asset, it will be open for the bank to take steps for possession of the secured asset in accordance with law. Stop. Writ petition stands disposed of. Let a photocopy of the report by the respondent number 6, handed over by the learned advocate representing the petitioner, be written with the records. Do you have a photocopy?
No,
you don't. এটার একটা photocopy করবেন জানা বাবু, এটা একটা photocopy করে আমাদের কাছে রাখবেন, অরিজিনালটা ওনাকে ফেরত দিয়ে দেবেন. We'll make a photocopy and retain one, and the other will be returned to you.
Yes.
All right. Has your other side come?
Out of court.
Out of court.
Any day, except tomorrow, any day. That suits the
Friday. Okay. Which item was it?
This is
58 of the government.
58 at order likhun to.
No.
None appears on behalf of the respondent number 1. Respondent bank. Stop. Next. Let the matter be listed on 11th Under the heading adjourn motion. Fileটা নিয়ে নিন।
আমি
64 I am for the petitioner.
Yes.
And pursuant to your lordship's order, my lord, we have added Airtel as a party respondent. We have first service also. And this matter pertains to, my lord, laying of optical fiber on my land without my permission. My lord, there is a policy of the state government which mandates that you have to take permission in case of a private landowner. And there is a committee formed at the district level and its appellate authority at the state level. At page 60, my lord, we have made the complaint to the district magistrate, who is the chairperson of that committee. Since no steps was taken, my lord, we have preferred appeal at page 68. My lord,
68.
68.
This is also pending consideration.
It's also pending consideration. But they may be directed to dispose of this appeal because the laying of fiber is already over.
Please come. The petitioner's prayer before the state level clearance committee
Respondent number 6.
under the West Bengal Telecom Infrastructure Guidelines, 2023. Being the respondent number 6 is pending consideration for a considerable period of time. Stop paragraph. Without entering into the merit of the same, comma, the instant writ petition is disposed of by directing the aforesaid respondent to consider and dispose of the representation filed by the petitioner in accordance with the said guidelines, after giving reasonable opportunity of hearing to all the necessary parties, and by passing a reasoned order at the earliest, but positively within a period of 12 weeks from the date of communication of this order. The reasoned order shall be communicated to all the parties. Stop. Learned advocate for the petitioner is directed to forward a copy of the representation dated 12th August 2024 along with all supporting documents to the aforesaid respondent at the time of communicating the order of the court. Disposed. Service taken on record.
In this matter, I am for the state.
But I am for the petitioner. But the matter relates.
Similar matter?
Yes, madam.
All right.
And a postmortem report is there. Police
Postmortem report is there?
Yes. On a
Page-
postmortem report, page 18 to 19. 18 and 19.
This is a report.
Type copy is 19.
Hmm.
Police report is page 23. Death certificate is at page 20.
Yes, any submission?
My lord, as per under section 27 of Wildlife Protection Act, my lord, 1972, there are some clause that who can get and who not. In this case, petitioners, so clauses I want to state, my lord. No person other than a person servant on duty, he was not on duty. A person who has been permitted by the chief wildlife warden, my lord, I want to submit my report, one report. And presentations are here we have submitted elaborately why we are not granting that sanction paid for. This,
Have you rejected the prayer?
my lord, we have rejected.
Where is the rejection?
No, para 15 is the, I have to show that.
Where is the rejection?
In my report, I have annexed.
In the report you have annexed?
Yes, because
How will the petitioner get to know? Which portion? Where is it?
No.
Which portion of the report?
My lord. Only read. No, my lord, we have stated here in para 15 why we are rejecting, but it has not annexed. 15. right to compensation due to wildlife attack is allowed only when such incident take place in illegally permitted areas, and the entry is when with legal permits and not in prohibited areas of the forest, allowing compensation for a death that occurs in a prohibited area. My lord, only this. He entered in a prohibited area, my lord, without taking any permission.
The facts of the case are similar to the case being WPA 21596/2024 within bracket Binarani Mondal MANDAL versus the state of West Bengal and others. Ajke list item 1. Stop. The court allowed the prayer of the petitioner and passed necessary order. Stop. The direction passed in the said judgment shall be applicable in the present case also. Stop. Writ petition disposed of. Report by the Deputy Field Director, Sundarban Tiger Reserve, written with the records.
60 আমরা মানে similar matter, my lord. Here.
Your matter?
Was my matter not to deliver a judgment in the morning? On the
Same judge, same
issue.
Same, similar matter.
একই জিনিস, same order over here.
Mal. Grateful.
Shall I have to put the report on?
Let it, since it has been forwarded, keep it on record. What is the use of keeping it with you? Your file will go. So it's better it stays here. In case anybody prefers an appeal, the record will go up.
Lordship.
Same order.
Great.
পুরোটা তুলবে না, যেটা বললাম ওই আমি কেস নাম্বারটার জন্য বলছি।
For the respondent bank, my lord.
Yes.
Lordship is kindly consider lordship last order passed by lordship, my lord. The auction purchaser, my lord, has filed a, my lord, writ petition by challenging the order of the DRET, my lord. Has assailed the order of the DRET. Now, my lord, technically I cannot oppose, my lord. I have the person who has put the property in auction. Now, my lord, I have raised a maintainability point, my lord. It should be before Article 227, not in 226. My lord. Last two occasions they have shot for time, my lord.
An accommodation has been sought for by the learned advocate representing the petitioners. Stop. On such prayer, the matter stands adjourned till 28th of April. 28.
Grateful, man.
My lord, in the item 68, my lord, I am appealing for the state respondents.
68, I am the petitioner.
My lord, there was an order to submit a report from the SP Con. My lord, may I submit this?
Yes, please. Did you get possession?
Yes, ma'am.
So your relief has been allowed?
Yes, ma'am.
Please come. Peruse the report filed by the Superintendent of Police, পূর্ব বর্ধমান। এটা হচ্ছে 23,458 প্রথমের মামলাটা। Where from it appears that Physical possession of the secured, now of the auctioned property has been handed over to Pawan Beriwal, comma, the writ petitioner in WPA 23458 of 2024. Stop. Learned advocate representing Pawan Beriwal admits handing over of possession of the secured asset. Stop. Next. In view of the above, all the writ petition stands disposed of. Report of SP written with the records date ta likhe neben 19 March 25. Yes.
Respondent bank.
My lord, I beg to appear for the respondent Reserve Bank of India, my lord.
Indian Bank.
I am appearing on behalf of the Indian Bank.
All right. Nobody is appearing today. None appears on behalf of the petitioner at the time of call. Petitioners released on 28th April. Respondent number 1, please record appearance, please.
My lord is fixing this matter on
28th of April.
But I appear for the petitioner, my
Yes.
Your Lordship may be kind enough to peruse the order passed by your Lordship on February 7th, whereby your Lordship directed the civil
score.
The report. After taking time, they have filed a report. But in my humble and respectful submission, the report is not in consonance with the direction of the Lordship. However, the report has been filed, which according to me seems that the credit facility of the petitioner before your Lordship has been upgraded.
Upgraded.
Yes.
So if it has been upgraded, then
But they have to accept that.
bank is not accepting the upgradation. Which bank?
Bank of Baroda.
Who is appearing?
I appear for civil, my lord.
Reserve Bank. Baroda is not here today.
Because of them, the civil gradation was downgraded. But now, according to civil authorities, I find that it has been upgraded. But there is something to be pointed out for your Lordship.
Where is your report? Did you file it?
Let it be kept. I have served copy.
All right. Okay.
If your Lordship kindly takes up.
Yes, which portion to look into?
Kindly takes up page 3 and paragraph 4.
Yes.
If your Lordship kindly takes up the sometime below.
Read out. You just read out.
I have to point out the place where
You just read. I'll find it out.
If your Lordship will kindly say the disputed loan account number such and
Yes.
such was reported with close
Right.
dated 16/1/2021. Amount overdue ₹0. Credit facility status as written off along with NDPDs as LSS by Bank of Baroda. However, the said disputed loan account number was not considered in scoring factor in as much as the same was reported with last report dated 16 January 2021, which is beyond the said criteria of 36 months for scoring with respect of the said CIR. But I do not know the abbreviated, the elongated terms of these abbreviations. Dated 18th February 2024 of the petitioner, a copy of CR being ECN number dated spring format is annexed here to and marked with letter R1. Now, in my humble and respectful submission for your Lordship, the report that is being submitted to your Lordship, if your Lordship kindly takes up page 8, annexer R3. it is 750 and showing good. Lordship takes a page 8, annexer R3. The scoring rate it is 715.
Yes.
Yes. According to my humble submission to your Lordship, it is good score.
All right.
But the bank is not admitting it. For the purpose of loans to be sanctioned to the petitioner before your Lordship may.
So what can the writ court do over here?
The action of the respondent bank before your Lordship is questionable one. And that is why I am inviting your Lordship to pass an order directing them to act upon the civil score, which they are banking upon, which they are banking upon refusing to grant loan. And that is
None represents the Indian bank. Indian bank? Which bank it is?
This Bank of Baroda.
Oh, Bank of Baroda. Stuff. CIBIL has filed a report before this court, wherefrom it appears that the score of the petitioner is 715. Stuff. The petitioner alleges that the Bank of Baroda is not acting in accordance with the CIBIL score. Paragraph. The bank is directed to take into account the CIBIL score of the petitioner for the purpose of grant of loan. Writ petition disposed. Report taken on record.
In that matter, I am appearing on the respondent number 2, 3, and 4, my lord.
I am for the state.
Joint inspection has been held. My lord, I appeal for the petitioner. Documents required to be submitted and documents submitted available. Next
WADC.
Next page.
Next page, my lord, can you see? Documents submitted available or documents required to be submitted.
All right. There are so many documents that are required to be submitted. Who are you? Who are you?
I am for the respondent number 224.
Who are they?
Who are the West Bengal Industrial?
No.
কি তো আমাকে তো এনগেজমেন্ট লেটার দিয়েছে
West Bengal Industrial Development.
My lord, I am appearing on behalf of the
WDIC.
My lord, he is my lord. It is my engagement. No.
Respondent number 2 is Director of Industries. I have engaged the letter, my lord. Engaged letter from
Who has engaged you? Department of Industry. Respondent number 2. You are WBDIC. Yes.
Joint inspection was done, my lord. Kindly, my lord, next day we will file, my lord. Today, my lord.
No, he has already filed it. You are not required to file because it is already on record.
My lord, I was appearing for the.
Give a copy to him because he doesn't know it. Please come.
Only one copy.
I was appearing for the petitioner, my lord.
Yes.
My video, I cannot enable the video, my lord. It's possibly disabled from the my lord host. My lord, may a copy of the report be given so that we can consider and.
The preliminary joint inspection report. Signed by the official respondents on 12th March 2025. Filed in court today is taken on record. Stop. A copy of the same has been served upon the learned advocate representing the petitioner. Stop. It appears that there are several documents which are required to be submitted from the end of the petitioner. What is the prayer?
My lord, the prayer was for my lord issuance of registration certificate part 2. This is pertaining to my lord the state support incentive scheme. And
the
we can come back indicating whether we had submitted the documents or not.
No. The petitioner is now it will be open for the petitioner to submit the documents as directed. Stop. On receipt of the required documents, comma, the Directorate of Industries, the Director of Industries shall take necessary steps in the matter for issuance of the
registration certificate part 2
registration certificate part 2
and my lord disbursal of the incentives if they ultimately my lord issue the certificate.
Stop. If the petitioner is found eligible to receive the incentive as claimed, comma, the same shall be disbursed in favor of the petitioner. Stop. In the event the petitioner is found ineligible to receive the incentive under the West Bengal State Support for Industries Scheme, comma, 2013, comma, the reasons for not granting the same shall be made known to the petitioner. Stop. Writ petition stands disposed. Everybody's appearance. Take back your engagement.
Yes, ma'am.
Engagement fero diye din. Report is taken on record.
My lord, only one liberty may I pray. In the event, my lord, they choose not to, my lord, issue the certificate and disburse. Lordship has said a reasoned order should be passed. In that case, should they, my lord, also offer an opportunity of hearing to us, my lord?
Opportunity of hearing at what stage?
My lord, because they will decide as to my right to the claims, because, my lord, we have satisfied
Your claim.
Yes, my lord.
আচ্ছা ঠিক আছে তাহলে একটা করে দিন তো an opportunity of hearing shall be provided to the petitioner at the time of consideration of the claim of the petitioner for grant of incentive.
Very deeply obliged.
Yes, next.
Deeply obliged, ma'am.
ডিসপোজ করলো তো হ্যাঁ আপনি
None appears on behalf of either of the parties at the time of call. List on 28th. Same order. না 75 দেখি ফাইলটা None appears on behalf of either of the parties at the time of call. List in the combined monthly list of June.
But 76, my lord, I wait to appear on the respond number 2, lordship. West Bengal Information Commission.
None appears on behalf of the petitioner at the time of call. Stop. The respondent number 2.
Respondent number 2, lordship.
Is represented. Stop. List in the combined monthly list of June.
Grateful, lordship.
We are for the state respondents.
My lord, I appear for the respondent bank, your lordship. My lord, there was a direction to file a report. My lord, I have already served upon the petitioner, your lordship, twice.
এটা দিয়ে দাও
Report filed by the Punjab National Bank is taken on record. Stop. None appears on behalf of the petitioner. List in the monthly list of June.
Grateful to lordship.
Lordship, I am appealing for the respondent number 3.
My lord, I am appearing for Reserve Bank of India. Respondent number 3.
3, both for 3.
He's my on record. He's my advocate on record.
Appearing for
I'm not.
He's appearing for 2.
yes, yes.
Lordship, I stand corrected. I'm appearing for
2 and you are 3.
No, he is appearing for 3.
He's appearing for 3.
Yes, sir.
You are also for 3. Respondent number 3 is represented. None represents the petitioners. List in the monthly list of June.
I'm grateful.
My lord, I am appearing on behalf of respondent number 10, 11, 12, and 13. Due to the medical emergency of the advocate on record, he had to leave the court premises. I am praying for not today.
All right.
And for the respondent number 8 and 9, my lord, this is the same matter in which I, due to miscommunication, my lord, I gave also
Appearance for somebody else.
Yes, respondent number 10.
Is
I
the
have
petitioner there?
It is no.
Give your appearance, proper appearance this time. Give your appearance. None for the petitioner? List in monthly list of June.
Monthly list.
You give your appearance and not the appearance of the advocate on record who is not present in court.
Okay,
all right?
Okay.
I am appearing for Reserve Bank response number 3.
All right, give your appearance. Same order, none for the petitioner. June.
Lordship, I'm for the petitioner and yes. By Mr. Caldwell Basu in this matter, Lordship. I'm praying for not today.
Why?
Lordship, he is not being able to appear today due to the resolution. He is not present in court today.
Due to the resolution, where is the bar? There is no bar in the resolution to appear.
He's not present today, Lordship.
Are you the advocate on record?
She's the advocate on record. Lordship.
Yes, why don't you proceed?
Lordship, he is leading us in this matter. Lordship, on the last occasion, we were directed to serve a copy of the order to the respondents. Lordship, we have done that. However,
Yes.
no one is appearing for the respondent. If I may hand over the affidavit of service.
Affidavit of service filed in court is taken on record. None appears on behalf of the respondents. Is there any urgency? No.
I'm not being able to take part in any of the tenders.
Why?
Lordship,
Lordship, for all the tenders that I'm submitting, Lordship, queries are being raised that are all new queries, and because of that, I am not application has not yet been decided, Lordship.
Which application?
Lordship. Lordship, if your Lordship may see, the first was the application for registration, which was approved, Lordship. Thereafter, as per the conditions of the registration, I was directed to submit QAP, which is quality assurance plan, Lordship. Therefore, Lordship, after that, I have been submitting the QAP, but every time I'm submitting the QAP, a new query is being raised by the respondent authorities, because of which my QAP is stuck, and because of which I cannot submit any further, Lordship. All the purchase order, I have received a purchase order, but I cannot supply because of non-approval from the respondent's, Lordship. I've received a purchase order dated 18th November 23, but I have not been able to supply to the parties, Lordship, because the QAP is not approved by the respondent authorities. Every time, Lordship, a query is being raised, I am submitting all the documents to them, but every time a new query is being raised by the respondent authorities, which was not new sets of queries which were not there in the previous queries, Lordship. If your Lordship wants, I will show your Lordship the entire list of the documents, Lordship.
DPO, none for the respondents pool. No? List on 16th of April. Let further notice be served.
Obliged, Lordship.
Is anybody there? None for the parties. June.
Appearing with the state, Lord. I appear for the respondent number 5, my Lord.
Record your appearances.
My Lord, there was a direction to file a report.
Please give.
My Lord, I have already served a copy. May I submit the report?
Yes, please. Report filed by the respondent number such and such be retained with the records. June.
And for the municipality, respondent number 2.
Yes. None for the petitioner, June. Record your appearance.
But 85, I appeal for the petitioner. This is that matter, my lord, where that matter warehouse of the Gram Panchayat was occupied by the state police authorities, my lord. But I have instruction that my lord, it is still in occupation, my lord. And my lord, interim order is also expiring, my lord, on my lord 30th of April.
30th of April.
My lord. So, my lord,
None appears on behalf of the respondents. Stop. The interim order that is subsisting in the matter is extended till 31st of July 2025 or until further order, whichever is earlier. List in the monthly list of June.
may it appear on my lord Monday, my lord.
Monday is a holiday.
Next Monday week, my lord.
Monday week. 21st of April. Yes. None appears on behalf of either of the parties. List in the monthly list of June.
I am appearing.
Yes.
I am appearing of the state respondent.
Sir, can you see your lordship's earlier order?
Division bench's order. What does it say?
No, there is a direction to file affidavit in opposition by the bank.
Since plea was taken on the first day, matter was heard, going to be disposed of without opportunity of defend by way of opposition. There was direction for giving opposition. Today I have received the opposition, and the direction matter to be heard by your lords in 3rd week of April.
A specific date is mentioned.
No, third week. Commencing of 3rd week. Yes. And my lord, one correction was there in the honorable division bench. If you lordship kindly see second paragraph, we find the word first page, second paragraph. The word starts. We find that the exercise of discretion by the learned single judge cannot be followed. It is shown. And subsequent correction has been also made. And otherwise, contrary to the view of that observation of the division bench, it should be faulted.
Yes. The orders passed by the Honorable Division Bench on 26th March 2025 and 1st April 2025 in MAT 316 of 2025 with CAN 1 of 2025 within bracket State Bank of India and others versus Hanif Ali Mondal and others are produced before this court. Stop. Let the same be retained with the records. Stop. Affidavit in opposition filed by the bank is taken on record. Stop. List on 21st April 2025. Reply
in the meantime
by the petitioner may be filed in the meantime.
Yes, an oral observation has been made by the honorable division bench regarding Reserve Bank of India circular
Guidelines.
6th of July 2017.
Zero
liability if I make a complaint within 72 hours. That means 3 days. That is to be. It was shown to honorable division bench. All point to be decided by you. I have brought that circular adopted by the SBI also on very.
All right. 88.
Get.
88, I'm appearing on behalf of the petitioner, Lordship. Lordship, in this matter, there was a direction. The respondent has filed 2 reports and we are to file our exception. So that I'm only praying for extension to file our exception, Lordship. Kindly keep the matter.
I am appearing for respondent number 6, my lord. Bridge and roof.
The joint debtors board, Lordship.
They have already taken twice time for extension for filing.
Again, why will time be granted? How many times?
Lordship, only this
Twice
time,
they have taken.
Lordship. Only for today, Lordship.
This is a matter.
Learned advocate representing the petitioner seeks extension of time for filing exception to the report filed by the respondents. Stop. On such prayer, list the matter in the monthly list of June.
Lordship, kindly keep it any
Exception.
this month, Lordship. Any
Exception may be filed prior to the adjourned date.
Lordship.
Prior to the next date of hearing. Yes, next.
I am grateful, my lord.
I pay for the respondent number 1 to 4 minutes.
Yes.
The writ is filed challenging the order under section 14 passed by the Chief Judicial. Writ has been filed challenging the order under section 14 of the SFAC Act filed by, passed by the Chief Judicial Magistrate.
Then what happened? Did you all take steps?
No, my lord, yet the physical possession has not yet been taken up, but the writ is not maintainable, my lord.
Then what about the tribunal? Has any application been made before the tribunal or anything of that
That is
sort?
not within my knowledge.
So you act upon the order. No, there is no stay order, nothing of this sort.
There is no.
None for the petitioner. List in the monthly list of June. Record appearance of the bank.
Your Lordship, I'm appearing on behalf of the petitioner.
90.
90, please.
90, can't be 90.
Your Lordships, I appear on behalf of the petitioner. As per Your Lordships, last order, Your Lordships, kindly, 19th March 2025. Your Lordship, this is the matter where we challenged the willful default notice by the respondent banks, which was based on a report of KPMG, in which they had relied on several documents which were not provided to us. Therefore, we asked them to provide us those documents. In those circumstances, Your Lordship passed the last order. Kindly have a look at paragraph 5 of Your Lordship's last order.
We have to take instructions.
Identification stage.
Yes.
List of documents. Supply of
Para 6,
documents.
Your Lordship.
Yes, certain documents were supposed to be handed over.
I'll tell you, Lordship.
If the documents were voluminous, then inspection of the same or scanned copies may be provided. What are the updates?
My lord, your Lordship is aware of that checkered past. Now, my lord, we found out,
Huh.
my lord, 20th of July 2024,
Hmm.
my lord, in response to several of his requests which were made, after my lord, giving reply to the show cause notice under the master circular for willful default. My lord, kindly have a look at this mail. I should give him a copy as well. Oh, he has. My lord, kindly see.
Who are you representing?
My lord, I am representing
Canara Bank.
Canara Bank. Well, I am the one who has issued the show cause under the willful defaulter master circular. Kindly take the bottom of the page, my lord.
Yes.
Received, find the rejoinder representation received from you. Well, this is for the first time in the rejoinder representation. He says that I don't have the copies of the document. Please also find attached the forensic audit reports in the below mentioned link. Then, my lord, kindly see whatever we have relied upon or we have reference in our show cause notice, everything was given to them, volume wise. Now, this letter does not find place in the writ petition, interestingly. All the other letters, 3 volumes, 500 pages are there, except this letter.
Your Lordship,
So let me
1 minute.
complete, then you make your
1
submission.
minute. And when did you forward this? The
20th of July.
20th of July
24.
2024. All documents which we think were relevant and which reference of which has been made in the show cause notice, all documents given. Now today, if you ask for documents which are unconnected with the show cause notice, but you think they are connected, well, I am not, or I should not be in a, cannot be obligated to give you those copies. So, well, all these documents have been already given to them. So, well, the interesting thing is that this 20th July 2024 mail does not find place anywhere in the writ petition, neither in the pleading.
Tell me one thing. From this document, I can see the second page.
Yes, my lord.
It is the confidential project flow report, volume 1.
All, yes. This is the name of the file.
This is the name of the file.
Kindly see the PDF volume.
Yes.
.pdf. These are the PDF files which we have forwarded.
Volume 4.
Yes.
Volume 4, part 2, part 3.
So these are basically the file names. So these are the PDF volumes which he has got. And what you will see, it goes from the manager of the bank. And there are letters before this and after this in the writ petition.
And there is nowhere mention of this letter.
Nowhere. I'll stand corrected. I stand corrected nowhere. We haven't found this mentioned anywhere. I'll stand corrected. On this ground itself, the writ petition deserves to be dismissed. Material suppression.
12th July 24, page 862, they connects the letter where also we have given them the same copies again.
No, my lord, kindly also see once, 862 once.
Volume 4.
Page?
862. 862.
This is 28 July, Target 12 July,
862. This should be volume
4.
Yes.
But volume 4. Lord, you will kindly give me a moment. 862. What I got? 862. Yes, I found. There's a letter your lordship will find
From us, from the bank.
from the bank.
12th of July 24.
Yes.
Sekhane page number 872 to them.
My lord, kindly see. On top, your lordship will see subject rejoinder to your reply dated 18 June. Now, my lord, this is the 20th of July. Now, my lord, your lordship will kindly come to.
872. 872.
My lord, kindly take once para 4.
Yes.
At page 863.
Yes.
As stated herein above, in April 2021, we appointed KPMG Assurance and Consultancy as forensic auditor to conduct forensic audit. Further, various concerns from the forensic audit report, which was already pointed out in the show cause notice, are reiterated herein for your ready refusal. A reference, I stand corrected. Now, kindly, my lord, kindly come to 872, which is the concluding part of the letter.
Annexes. We have enclosed.
Yes.
Absolutely at the bottom.
Confidential file.
Yes, my lord. Kindly, my lord, see the paragraph before that confidential project flow report. Forensic audit report of Saxena and KPMG. Please note, kindly see, my lord, volume 1 to 4. Please note that the forensic audit report is voluminous, running into more than 1200 pages, and hence we are providing you herein below the link to access the forensic audit report to your email such and such, K.A. Kanoria, I stand corrected, my lord, kanoriahk@gmail.com. Then, my lord, your lordship will see confidential project report such and such. Now, this is the letter which was dated
12th of July.
12th of no.
July. 12th of July. 862. 12th of July.
12th of July. And what I showed to your lordship was 20th of July. Once again.
So twice over, you forwarded all documents.
He has everything. But basically, the whole idea is to circumvent the entire proceeding, so that eventually, my lord, this is the, my lord, it is inevitable. He understands. He is trying to prevent the inevitable. Letter after letter, representation after representation. And my lord, the willful defaulters master circular, neither jar developers contemplate that, well, these repeated representations. You made a representation, I have responded.
Now it is at the identification stage only.
Yes. Because of all this, it's pending. The identification committee is now, my lord, reluctant to proceed any further because the matters are in court.
Yes.
Your Lordship, only two things. Your Lordship, give me just only one day to come back with instructions on this email. However, Your Lordships, I must point out, in our letter at page 882, volume 4 of the writ petition, Your Lordship, we have enclosed a list of documents that we need to respond to this show cause notice. Your Lordships would kindly keep in mind, in this case, I am not in management of the Shrey entities now. The Shrey entities have been superseded by the RBI, and today it's under a new management. So, Your Lordship would recall, in similar matters where show cause notices were issued to declare my account as fraud, orders were passed by this honorable court, 4 orders, Your Lordship, whereunder it was said that not only the documents relied on have to be provided, which also in my respectful submission have not been provided, I shall point that out, but also those documents which I need to effectively respond to this show cause, considering the fact that today I am not in management of the Shrey entities, Your Lordship, those also have to be provided to me. So kindly give me a day to get instructions on this. I shall give this response. I'm being led by Mr. Jishnu Chaudhary, Your Lordship. Today he's in some difficulty, and I shall make my submission on the next day. That's page 882, Your Lordship, volume 4.
And volume 4, and for how many pages are the documents that you sought for? 85, 86?
Goes up to page 889.
889?
The forensic report is, Your Lordship, of 300 pages, plus
Yes.
annexures. I shall
1200 pages forensic report. I have said that in my letter.
That
My lord,
is-
I appear for the petitioners, my lord.
report.
I'm with Mr. Chaudhary. My lord, for some reason, the host has disallowed my video, lordship, which is why I can't turn my video on. My lord, let Mr. Chaudhary continue. My lord, all that I'll point out is, lordship, since we are not in the management of the Shrey entities for the last 4 years, there is a distinct difference with the situation which Mr. Bose is pointing out. I do not have access to the documents. What has been stated in the auditor's report, lordship, is that from a perusal of 280 loan accounts, certain instances of willful default can be seen. Now, lordship, kindly appreciate, without looking at, they've referred to minute loan books, they have referred to letters written while disbursing those loans, none of which are being given to me. And for 4 years, I have not had access to these documents. I don't know under what basis Mr. Bose submits that I already have these documents, because it has been Mr. Bose's client's case that I'm not in control of these entities for several years now.
That should be ground enough to
And
absolve
lordship, I do not understand the hide and seek.
one-liner.
I do not understand the hide and seek, lordship. If
Who
they
is
have
the
the
petitioner
documents,
over here? Who is the petitioner?
Heman Kanoria.
This letter, the letter that you handed up just now, the email communication was
Yes, my lord.
forwarded to Sunil Kanoria. How is Sunil related to
Same. Account is the same. Son and father.
my lord, they are brothers.
Or I stand corrected. Maybe son.
They were both directors in the Shrey entities, which was superseded in 4th of October 2021.
And 862 is also.
So, beloved, if the supersession is
Page
the ground,
872, page 872 of the brief, there are several email communications.
Yes,
Have you got those?
Lordship.
That you
I have.
got.
Lordship. But none of them.
That apart, you
Lordship.
require from pages 882 to 889 these documents.
Lordship, because the audit report relies solely on these documents. If Lordship will see the audit report itself, they are merely inferences drawn subjectively from these 280 loan accounts. All that we want, Lordship, is inspection of these loan accounts, and the matter ends there. I will have no further. And Lordship, I do not understand if Mr. Bose's client is interested to proceed. All they need to do is give me inspection of these documents, and I will have absolutely no excuse to not continue with these proceedings.
so I will proceed on the basis of his
Will
direction.
appreciate the Shrey entities are today under the control of a company which is
One
owned
minute.
by Canara Bank.
Please, 1 minute. Thing is, if you go on like this, you will never be able to identify.
Fine.
So it is better
Fine.
that you give inspection of these documents to the petitioner so that you can proceed at least. I do
But
not know the documents
My lord.
which you have forwarded,
My
the
lord.
list that you submitted just now,
Yes,
whether
yes.
they are the same as has been sought for by the petitioner in pages 882
Madam,
to
may I
889.
just say this? Today he may seek for multiple documents. Now, if those multiple documents has no relevance
It
to
is
my
according
show
to
cause,
you,
yes. So
you
then,
say it
then
is not relevant.
So that
For
so,
them,
well,
it
allow
is
me-
relevant.
to them if it is relevant, and I refer them to the show cause and I pass an order, then my order will suffer from
Why?
glaring infirmities.
Why will you permit
Because
this?
I say that these documents are not relevant. These documents I have not relied upon in the show cause.
What is the harm of these documents you provide inspection of?
Is that
No, not on that.
You
I have
will
understood
not
what your lordship is following. That if the enclosure A at page 882,
Yes,
this
enclosure A.
list of almost, my lord, 59 documents which they have referred.
Yes.
If we have in
you
our
have them,
custody,
yes,
then we
yes.
can give it.
Right, right.
This or not.
You say if you do not have, you do not have it.
Very good.
They also with copies of engagement letters with UCO Bank access.
Then you say it, I don't have it.
Please come.
Very good.
My lord, if the
Then if you would it be a
My lord-
lordship pleasure to
my lord,
indicate
may I humbly submit one
Pages
terms of
pages 882 to 889.
my lord.
My lord, may I make one submission, lordship? It is not open for the bank to say that they do not have any of these documents for the simple reason. One,
It's a good ground.
the bank,
It's a good ground
without
for them to
seeing these
challenge.
documents, the bank could not have proceeded in the matter. And the next,
Communication.
lordship, and the
Dated
next
ground for you.
20th
Good
July 2024 by
Ground
the
for you, Mr. Sarkar. Challenge it.
manager of the
Next.
bank, addressed to Sunil Kanodia, forwarding several forwarding link of several documents has been placed before this court. Stop. Learned advocate for the petitioner submits that the documents referred to in pages 882 to 889 of the writ petition will be required for filing a meaningful reply to the show cause issued by the bank. Stop paragraph. It appears that the matter is pending consideration at the identification stage. Stop. Without the proper documents, the petitioners claim, that they are unable to file reply to the show cause. Stop paragraph. To put the issue at rest, the bank is directed to either give inspection of the documents sought for by the petitioner at pages 882 to 889 or to provide soft copies of the said documents to the petitioner.
Or indicate if it is not within our custody.
Stop. In the event any of the documents sought for in the aforesaid communication, the same shall be made known to the petitioner. Stop paragraph. Now the matter can be disposed of. What is the use of keeping it?
My lord, may I make one submission? What will happen,
my
lord?
lord,
Essentially, what has happened is, my lord, I'll just take 1 minute, my lord. I'll leave it to my learned senior friend. My lord, if today they will not disclose inconvenient documents to them, what Mr. Bose says is irrelevant is actually the ones which will show that there can't be willful default. They will only disclose the documents which are convenient. And this, my lord, is absolute abuse of process because I have to be given the documents which you are relying on. All that I'm praying, lordship, is
Matter on 6th of May 2025 for recording further updates.
My lord, only one respectful submission. My lord, your lordship has been pleased to record my learned friend's submission. And my lord, kindly record that, my lord, that we, appearing on behalf of the bank, we dispute that submission. And Sunil Kanodia is the second petitioner in this writ petition.
Right. It's if Sunil is there, it's
Yes, it is there. And my lord, kindly record that the submission that they have made, that they are relevant, this is disputed by us. These documents, according to us,
well, that is for us to decide what we find relevant. It's not for the bank.
This will give
who's seeking
rise to
punish me.
multiple, already a suit pending challenging the forensic audit report.
Well, that's not, that is a
Now they say forensic audit
these are
report
incorrect
documents you give.
submissions. Grateful, lordship. Grateful, my lord.
Lordship, prior to taking up of item number 91,
I cannot hear.
Item number 89, I was appearing for the state led by Mr. Shudipta Panda because of the.
Has order been passed? If order has been passed,
It has been sent into the monthly list of June if the appearance may be considered. Subject to your lordship's convenience.
89 owner appearance to record coincidence. It's only your appearance that will go down and not anybody else, either top or below. Yes, 91 is anybody there? None for the parties, June.
Well, in the matter, I am appearing for the Bar Council, my lord, alleged contempt.
Exceptions.
Earlier, my lord, your lordship has extended the time for filing report. I am filing the report.
Copy given?
Yes, your lordship. This is the exception.
All right.
I was directed to file the exceptions and it has been duly served.
What about the proceeding over there?
Proceedings is not continuing, my lord.
Virtual
Because, my lord, we have already filed an application seeking for review of the order passed by your lordship. And since that order was challenged by another person, my lord, who is not a party to this contempt application, before the honorable division bench, and the honorable bench had been pleased to pass an order. And
where is that?
My lord, your lordship will find in my report, my lord, at the last portion at page 10, my lord, running page 10, passed by the Honorable the Chief Justice and Honorable Justice Bibhash Patnaik, Division Bench. And my lord, in respect of this order, we also filed an application seeking for modification. That has not yet been disposed of. Because
You want modification of the division bench's order?
Because my lord, he had also...
Whatever is the because they make submission before the honorable division bench. Please come.
Your lordship, the honorable court had directed them to provide the virtual link. And
yes. They will provide division bench's order. They will certainly provide a report. Report filed by the Bar Council of West Bengal and the exception thereto filed by the petitioner be taken on record. Stop paragraph. It appears that the matter was carried in appeal before the Honorable Division Bench. And
lordship, on the last order, it has been recorded by your lordship. On the last order, the observation of the Honorable Division
Yes,
Bench
my lord.
recorded.
Proceedings may be continued in view of the order passed by the Honorable Division. That was the order.
Virtual link.
কি বললাম?
Virtual link.
Honorable Division Bench and the same stood disposed of. Video order dated 5th February 2025. Stop. Paragraph. Learned advocate representing the Bar Council submits that an application for modification of the said order has been filed and the same is pending consideration. Paragraph. It appears that the Honorable Division Bench was pleased to hold that the proceeding before the Bar Council need not be stayed and the proceeding can proceed on the virtual mode. Stop. Next. The Bar Council is directed to take steps in terms of the order passed by the Honorable Division Bench. Stop. Release the matter for further consideration in the month of June 2025.
Deeply obliged.
Next. Next matter is also same. No, 92. 93. अब देखिए लाभ नहीं. Let a report by the CBI. अच्छा ठीक है. None for the parties June.
93, I am for the respondent number 1, Union of India.
Record your appearance. Somebody was there for the CBI.
Yes,
CBI is not appearing today.
Who is the answering respondent?
CBI is the answering respondent. Very well. June. What is there? June.
But I am for the petitioner. This matter was heard by your lordship. Wherever the order of the appellate authority under the Apartment Ownership Act is under challenge, the appellate authority has permitted the adjoining land, which is not part of the project, to be included in as a part of the common law facility. That order is under challenge. Now, my lord, do your lordship call for a report from the state?
My lord,
state is not appearing.
Who are you for?
My lord, I am appearing for the proposed added party.
Proposed added party?
My lord, I have filed an application for addition of party just day before yesterday, and I have accordingly served the application to the appearing other parties. My lord, I am having the same grievance as just like the writ petitioner hearing.
And
Is it your land that has been
no, my lord, no, my lord.
Flat owners.
We are the flat
We have
owners.
been given a garage.
You are also a flat
Yes,
owner?
yes, my lord.
Or same footing?
I want to not file one affidavit subject to my lord's permission, which includes not the building plan and the completion certificate. I have checked up, my lord, neither in the building plan, the master plan, or in the completion certificate, this adjacent plot is there. So kindly allow me to not file this, and I will give.
My lord, now
kindly fix not any date, my lord. 21st is possible, my lord. We shall give a notice to them because they are
Alright.
proceeding with the, my lord, issuance of for me.
What
yes,
is
my lord,
this?
this is the affidavit of service.
No, let it be added. The can is not. Is it appearing in the list?
No,
Can
but
the can is not
can
appearing.
is not appearing.
It
You,
has
my lord, it is just filed the day before the inspection.
हाँ अश्विन ठीक तो filed by the petitioner is taken on record. Stop. An application has been filed seeking addition of party by similarly circumstanced. How many? One?
Yes, my lord, one.
By a similarly circumstanced applicant. Stop. The application is not appearing in the list. Stop. Let the same appear in the list on 24th of April. Let notice be served upon the non-appearing respondents, intimating the next date.
Some precedents may be given because they are issuing the forming notice. Now they will form the association. If they form, my lord,
On last date, so far the last order is concerned.
this is the
I have
order
seen
your lordship called for
the
the
respondent number 4, who is the promoter herein. He is also appeared and very much aware about this instant writ petition. But after knowing all these things, the promoter is very much hurriedly taking steps for the purpose of formation of the ownership association.
And that
Promoter
is
appeared,
already.
Promoter Siddhartha Banerjee appeared. Their
Promoters have
stand is
appeared.
that the deed says that they can give an adjoining land, so it can be included. They argued on that the definition of property includes land only. But we shall argue on that, but not late.
Yes, yes.
I shall give a notice. Some precedents may be given.
Yeah, all right. You come. Let us see.
Fine. 24.
Extremely great.
Application is not in the list, so it cannot be taken. All right.
96.
Nine.
For the
Number 96, I am for the petitioner, my lord.
Yes.
In this
But,
matter, WBSCPC. This matter where the auction has taken place and it has already been completed, payment has already been given, goods has already been sold.
What remains?
That's why I am
my lord, in this matter, my lord, I am led by Mr. Siddhartha Banerjee, my lord. My lord, today he is not available, my lord. Kindly make it note today, my lord. We shall come back tomorrow. We have also filed a supplementary affidavit and also given.
Saying he's not available. I saw him in court just now.
Yes.
My lord, just now I got information.
Back, I saw him over here.
Already payment has been given, goods has already been sold, completed.
What remains in the writ petition? Are you the advocate on record?
Yes, my lord, I am the advocate on record, my lord.
The submission is that the payment has. What is your stand? Who are you in the tender process? Did he participate in the tender?
Yes, participated in the tender, but there is a latches on their part. It has been closed after giving the notice. Subsequently, fresh tender has been issued and the materials has already been sold. But everything has been completed on 30th of January 2025.
My lord, in that aspect, my lord, we have filed a supplementary affidavit.
They are claiming that
Your supplementary affidavit is already on record. How many supplementary will you file?
My lord, last occasion, my lord, leave was granted to file a supplementary affidavit. The date was
Supplementary is already on record. 11th of February.
But their claim is to they want to refund that amount from our side. But that is not that because there is a latches on their part.
Is that the prayer for refund?
No, their
that is a fresh cause of action.
Yes, that is a fresh cause of action. But nothing
Please
remains
come.
in this petition.
In the instant petition, the petitioner has prayed for a direction upon the respondent authorities to accept the balance amount payable by the petitioner with additional charge in respect of the e-auction notice dated 17th December 2024. Paragraph. Learned advocate representing
WBSCDCL.
WBSCDCL submits upon instruction that the subsequent e-auction process stood completed and the goods in question have already been sold off. Stop. Payment has also been made To whom?
But payment has already been made to the, that is the petitioner, that is the pro-bid amount has already been paid. So for the pre-bid amount is concerned, that they are not entitled because it amounts to forfeiture of that amount as per the
Whatever is forfeited
Yes.
is forfeited. Then this payment is in connection with the petitioner.
Yes, this payment has already, pro-bid
My lord,
has already
in
been
that aspect, my lord, we have been paid 12 lakh rupees.
The
My lord,
amount has been paid to the petitioner. Payment has been made, so the pro-bid amount has been paid to the petitioner.
not the
Stop.
pro-bid amount was 12 lakh rupees, only 2 lakh rupees was given back to us, my
The
lord.
pre-bid amount of the petitioner stood forfeited. Stop. Paragraph. The petitioner is aggrieved by the same paragraph. It appears that the same gives rise to a fresh cause of action which cannot be decided in the instant writ petition.
My lord, kindly give us not today, my lord. I shall come back tomorrow, my lord. With all
Open for the petitioner to initiate further proceeding challenging the forfeiture of the pre-bid amount. Writ petition disposed.
I'm deeply aware.
My lord,
Next.
Your Ladyship, I'm appearing on behalf of the petitioners.
Yes.
I'm being led by Senior Advocate Krishnaraj Thakkar in this matter.
Yes.
He's out of station today, Your Ladyship. I'm praying for notary. Kindly fixes it for tomorrow, Your Ladyship.
I'm appearing for 9. Could I, my lord, beseech your
R1
lordship?
and R7. On behalf of the respondent number 13, 1-3.
Could your lordship kindly, my lord, keep it after the 18th?
Well,
See,
since
my
the
lord, they have
petitioner
filed a
is
suit,
seeking an
my lord.
accommodation, well, kindly keep it sometime.
An accommodation has been sought for on behalf of the learned advocate representing the petitioners. Stop. Released on 21st.
Phone.
My lord, could it be 22nd instead of the 21st?
Yes, my lord,
22nd, my lord, pray for 22nd.
22nd.
Great. I'm extremely grateful.
22nd, very well. Obliged.
Yes.
Your Lordship, back to appear on behalf of the petition in this matter, Your Lordship. We have
Section
filed-
14 application pending.
After filing of the writ petition, order has been passed by the London District Magistrate.
Then your writ petition has become infructuous.
The order has been passed, Your Lordship. The further proceeding will be gone for taking physical position, deposit of
You
police
take
works,
it, but
etc.
then the relief that you have sought for has been allowed.
Lordship.
The relief sought for by the petitioner has been allowed during the pendency of the writ petition. Stop paragraph. In view of the above, the writ petition stands disposed of. Order dated 13th March 2025, passed by
same
the
order in
district
100
magistrate. 99?
99 is fine. that is-
Different.
Yes.
আচ্ছা 100 তে same order হবে 99
99, Your Lordship, section 14 application.
Has to be passed. 97 it has
98 এ order হলো 98 এ order হলো
97 কি হলো
97 তো adjourn হলো না Yes.
99, I am for the petitioner, Lordship.
Order has not been passed. Section 14 pending.
Lordship.
Section 14 pending আমাদের একটা order আছে না District magistrate. You are appearing for the bank, not for the bank, the state. ঠিক আছে আর ডাকতে হবে না
Lordship, 100 the same order. Lordship, 100.
100 is same as 98.
Same as 98, yes. And 99 necessary order be passed. Obliged.
99 disposed of.